Hello, hello. This is Attorney Mike Gravel coming to you from Chicago. As usual, let's get started. They're just got
And now he's in orange. Lol.
Morning.
I guess there's no need because the
morning,
jury
Kurt.
is out for deliberation, so there's no need for him to be in street clothes. But I do appreciate the orange look. We're celebrating Halloween early over here.
You're ready.
Oh, he doesn't get a suit for this. I guess he's not going in front of the jury.
That's right.
Appearing as authorized representative for my client.
Oh, dear Lord.
It's a nice color orange. I'm going to get a couple of those myself.
Make my exemption available.
Too early for the Fez.
All obligations and charges connected with this case. I do not dispute any of the facts in the charging instrument.
He keeps saying he doesn't dispute any of the facts, which in the event of a guilty verdict makes the courts of appeals job real easy. Real easy.
The 14th Amendment.
You don't dispute any of the facts. Okay, well, end of analysis.
Thank you. The record to reflect that the individual known to this court as Darrell is present in custody in person. He is wearing his jail attire this morning.
Also, he keeps saying I receive for value and I give for value. What value does he think he's giving back in this contract? What consideration is there in this contract? Just out of raw curiosity.
Through the overnight or third
His
shift
pure
hours.
presence currently is value.
Oh, okay. His presence is the consideration. Okay. It's an appearance fee. I get it.
Bailiffs yesterday evening. Then, of course, we are open and the jurors are here and they will be instructed to start their deliberations. The only other thing I would put on the record is I have received information regarding the Reddit post that there was a subsequent post from that website indicating that it was a prank. And so I don't know to what extent the Sheriff's Department is looking into that as well, but it's my understanding based on news reports that that entire post or site was taken down. Not the site of Reddit, but it's no longer, I believe, viewable. But there was that additional information regarding that, at least from the administrator, I believe, of that post. So I just wanted to put that on the record. And if and when, or I should say when, the investigation is completed, I will assure the parties that you will be provided with that information.
So,
go ahead.
So it's being called a prank.
The person who posted it called it a prank.
Post itself. Yes.
So we don't have any idea if that's a fact, though, right?
You're correct. I'm just putting on the record the additional information that's been reported on. And then again, once the Sheriff's Department concludes their investigation, it will be turned over to the parties. So at this point, until there's a question or a verdict, courtroom will remain open. I'm going to be working in my office on other things and will be available.
Drinking?
Of course, if there are any questions or if a verdict.
Would you like to start a live stream? Hey, Judge. Judge.
Oh, go ahead.
Join the stream. We'll send you a link.
Go ahead.
That would be fantastic.
I'm still very concerned about this whole.
I'm sure you are. I'm sure it's keeping you up at nights.
Fully read
as
it
opposed to
and,
you seeing the slightest hint of leverage and hope.
It's very concerning.
There's an investigation, sir.
Investigation, sir.
Yeah, that is what the
There's an
judge just said.
allegation that the integrity of this judicial
I think
process
murdering
has
6
been
people is
compromised, especially
concerning.
with the jury. I take that incredibly seriously, which is why I turned it over to the Sheriff's Department.
I would like Your Honor to, if it pleases the court,
It does not.
if it pleases
Whatever
Your
it is
Honor,
you're
I
going
would
to say,
like
it does not.
Look at some alternatives. If I may bring up the in regards to the language, I also want to state that for the record, this did not come about from the prosecution side, from the defensive side, and certainly not from Your Honor's side.
Thanks.
This is something that just pretty much sprang up.
Yeah, we
A
know.
lot of my concern, though, just not from just the language in the actual post, but I was kind of concerned that I was the last one to learn of this information. It had been known. I wasn't aware of it until after 6:30 last night, or around that time, because I don't want to misquote the record, but somewhere around that time.
It was shortly after 7.
Oh, so it was after. I didn't know. I thought it was. I knew it was after 6:30, but I didn't.
There is a clock on the wall.
Incorrectly state.
We keep seeing it.
Your
I can
Honor,
address that for you right now if you would like.
yeah. If it pleases you, Your Honor, I would like to request some alternatives to this issue.
Like what?
What's your specific
Directed verdict
My
is innocent.
specific request would be to
If he says mistrial, I'm going to scream.
look into a mistrial, and also any alternatives
How did I call
along those
that?
lines, short of that, or along those lines, or a mistrial. I was looking at some. Obviously, yesterday was very, very long for everybody.
Lord,
sweet Jesus!
No kidding.
And as you know, because of my status here in the jail,
we got a 3-member court sitting
allowed
over
to
here, guys.
have,
What do you think?
law
Of the
library
motion for a
time
mistrial. You guys
up
feel
until a
that?
certain point of the evening, and
I'm
then I have
gonna
to
vote
shut it
no.
down per jail policy. So I was able to find a few different things that I wanted to bring to Your Honor's attention, if I may.
Go ahead.
One being United States versus Perez, 22
Ooh.
U.S. 579.
Probably not 22.
And that specifically, I think it's referenced because that one is
probably
pretty
not
old in
22.
itself, but it's referenced in a lot of the other case laws that I actually found. I think, and I could be, if I'm interpreting this incorrectly, I apologize.
1824 case.
They kind of use that as kind of like the benchmark for what they refer to as manifest necessity. That's kind of like one of the leading cases that each one references in regards to issues similar to things like this when it comes into play.
It also only applies to capital cases.
And it specifically points to trial judge's discretion. And I think that's kind of like the leading one. Also, I looked at Brown versus Rushton.
I have a YouTube channel.
572F.3D.
People are saying I'm loud, so I'll turn myself down a little bit more.
Which speaks to
turn myself down another 10%.
It speaks to the same thing. It speaks about
fucking hate StreamYard.
Manifest necessity. It speaks about if there's an issue of exculpatory evidence, things of that nature. Also, United States versus Bates. That's BATES.
Yeah, Seeker was asking for sub.
917F2D388. And that speaks of potential for an impartial verdict. Specifically, it says along the lines of
I love this because he's just proving his
if an
competence.
impartial verdict can
He's
be
actually
reached,
making a legal
if a
argument with
verdict,
citations.
conviction could be reached, but would have
it's
to
wrong,
be reversed
but
on appeal due to
It's
an
wrong.
obvious procedural error in the trial. That's
But
one of the main issues.
I can follow the logic tree.
Speaks to.
Yeah.
I also looked at Arizona versus Washington, 434 U.S. 497, and that speaks to what I was stating before. It says neither party in a case has a right to have his case decided by a jury, which may be tainted by bias. And I say that because it certainly wasn't anything dealing with the prosecution. They had nothing to do with
we're
this.
talking
The
about a
defense
Brady
had nothing to do with this, and certainly you, Your Honor, had nothing to do with this. But just
again,
for the concern factor,
Good
language.
Question. Someone should raise that.
It's pretty clear that this, if not directly came from a juror who sits on this panel, it came from someone who sits in this courtroom every single day. The language,
or someone that watches Law Talk with Mike and is a moron.
Directed towards you, Your Honor, directed towards having
yeah,
clear bias towards the defense.
All of us have sat in this courtroom every
Some
single
of
day
the
at
things
this point.
that they quoted,
John's channel's
having knowledge of is extremely concerning.
J. Robine Law.
Kurt's channel will
Extremely
be
concerning.
soon.
And going back to some of these case laws that I cited, it talks about something to the effect of the ends of public justice. But I think that is leaning more so towards the judge's discretion, I would say, at least from how I was interpreting it.
I have to give it to him. He's been getting better a little bit.
Educated in a lot of
the first time he's getting deferred,
but how I was interpreting it.
He has actual citations. Granted, none of them are relevant, but
he has a future as a jailhouse lawyer.
Definitely a concerning issue. Is definitely something that I would request Your Honor to take a long look at. Look at some options. Look at some alternatives. And those case laws I cited talks specifically about that, options that you, Your Honor, can look at and use your discretion to see if it's appropriate in any way. But I'm extremely concerned about this. If anything, for cautionary reasons,
how about all the
I believe,
you
Your
when
Honor,
you drove
that
through a
you
parade?
definitely should
Oh God.
take a look at everything I'm saying
too
here
early for
in
this
these
stupid-
case laws and
I feel like I've literally
What's
said
the
that every
request,
day
though,
we
that
watch
you're
this.
making based upon the case law that you cite. I heard in there mistrial, but I want to make sure I understand your request for relief and what it is.
you say request for
Relief.
relief.
What are you asking me?
What is your
to
prayer for
do
relief?
based upon the information?
What do you want?
What do you want,
that
dummy?
It is an element of
Information we have
standing. There
about
has to be
the
something
Reddit
the court
post.
can do about it. So
In this
what do
trial.
you want me to do about it?
I guess my request would be,
Mistrial?
because of the concern of this, to look at a mistrial, or at the very least a discharge of the jury at this time.
That's the
So-
same thing, dummy.
This can be resolved. This is alarming, to say the least.
Do you want to convert this to a bench trial, please?
This
Oh, I'd be so down. We could
post,
be done in 20
and
minutes.
I don't know what Reddit is, to be honest. I've never heard of it or used it, so I don't know the extent of. It's almost like this could be like a snowball type of thing. It can start with something that's this small, and then it can snowball out of control into something totally different.
What are you talking about?
I don't know the extent of this website.
A bench trial is when the judge makes the decision, no jury.
I don't know who. Well, I think the name of the person who sent
You've lost the plot. What she wants
who
to know is
alerted the clerk of
what do you
courts
want her to do about it? You said mistrial.
To this post. I think his name is in the email.
I
But
would
then
love to
that
give her
even
a
asks
bench trial.
begs the question of, how did this person?
I think she
come
probably
across
would
this
too.
site? What is their significance to this?
She actually has
there-
to write out her reasoning, though, so it takes some time.
I mean, clearly this points
Yeah,
at
that's a fair
the
point.
court's integrity. It points at your integrity, Your Honor. It's alarming. It's
How
very
does some
alarming.
Reddit post
And
have
if there's
anything
a
to do with
chance
her
that
integrity?
there could be hidden bias in this jury, it needs to be addressed now rather than later.
God, please let the jury come back right now while he's still talking.
This is very concerning.
Yeah, that's what I'm waiting for.
Well, thank you for bringing up your concerns. Let me turn to the state if they want to respond, and then see what other issues they want to cover this morning.
Yes.
There's the original
It
post
has that flavor
from a
of it.
subreddit thread called Justice for Darrell. That's the copy that the defendant has in front of him. That post was edited last night, claiming that it was a prank from the start and that the original poster was didn't think it would get that far out of hand. The way that Reddit works, the only person who can modify the content of the original post is the original poster, and because the jurors have
They were all sequestered, so it couldn't have been
no
one of
access
them.
to any electronic devices, I think it's safe to say that our 12 jurors back there are not the original poster.
That's pretty good
So I
evidence.
think
Yeah.
that puts that
That's
issue
pretty good argument.
pretty much to bed. It's still obviously under investigation because the court takes it so seriously, but there really is no actionable or any real reason why we should doubt the jury's being unbiased in this case.
I object to that on the grounds, Your Honor,
I'm
that,
sure you
Of course
do.
he objects.
like you just stated, it's an investigation going on. And if there's an investigation, then that clearly says that something is amiss.
No,
We have
that's
16
not what that
well,
means.
15.
No,
We have 15 jurors.
it means we're still trying to determine if there might be something.
There's still too many questions that we
Yes.
don't know.
Yeah.
Too many. I don't think anything's put to bed because we don't know. It's unfair to say that the issue was put to bed when there's still so many
Just say,
questions
okay,
left.
I'll take it under advisement.
there.
Go back to your desk.
I'm
ignore
sure
the whole
you
thing.
reviewed
That's
it
what you do at
yourself,
this
Your
point,
Honor.
right?
You see
See,
the
Mr.
language
Brooks,
in
it's a really
this,
good argument. I'm
whatever
going to take it
this
under advisement. Go back to
thread
your
is.
desk and think
I
about
don't
it real
know.
hard.
I don't know what this is. It's clearly a post from somebody
Pretty
who
sure
has intimate
AGA
knowledge
gave a
of
really good
the trial
explanation
and,
why it
and
couldn't be
what's
one of the
going
actual
on in the
jurors.
trial. I don't think. I mean, common sense would tell you that this is
No, don't
someone
start.
who's very close to the case. Whether they
What's the
were
common
intended
sense,
to be
Darrell?
funny, whether they were intended to try to prank the court or anything like that, we don't know. That could be anybody's guess. The language in this, the way that it's formatted, they lay out 4 specific points of what they think. They point to certain language in the case.
No, just stop.
Yeah. Mm-hmm.
They make references to saying when we
Right.
were in the room, they got certain feelings from when they specifically refer to themselves and a group. That would be we,
Sure is.
plural. They say, and I have to admit, I am biased against the defendant for the horrible acts he did. And they attack you, Your Honor. They clearly attack you. This is
They attack you.
if this is someone's idea of fun, is anybody's guess, but I don't believe that it is. Clearly,
Well, we've seen your idea
by
of
the
fun
way
over the
it's
last 2
formatted
weeks.
and by the
So,
language that is in it.
yeah.
This is clearly someone with intimate knowledge of the case and what's going on. Clearly. There's no other way to interpret this. You can tell by what they're laying out in the language that they're speaking with. if this is clearly someone close to the case, and
No.
because of that, it still has to be.
Mike, I have a confession. I actually live in
I'm informed of the
Waukesha, and I'm a
investigation, but
juror
there's still too
on
many
this
questions left
panel
in the
right
air
now.
just from this.
And
How can you say
I have
anything's
access
put
to a
bed
live
when there's
stream,
still
and I've broken out from the
investigation?
jury room to talk to you.
For all we know, what if
This is an
what if
exclusive.
this turns up that it was someone
Love
on the
it.
jury, or what if it turns out that more people are involved in it than just whoever this
Oh,
anonymous
please.
person
I
was
don't
who left
blame
the
him for
post?
exploiting it. He's just not good at it.
It's too many questions and it's too concerning. What if something like this springs up again at the last minute? We've been going through the trial now for
Jury is in
basically
deliberations
3 weeks, the better
right
part of 3
now.
weeks.
They do not have
And
access to
even-
electronic devices.
Even in
There is nothing
court
that's
days
going
leading
to
up to the
happen
trial,
that they
we've
can
never had
possibly
anything
see
like this happen.
between now and
Nothing
when
like
they
this
throw
has
you
been
in
brought to
jail
your
for the rest
attention.
of your life.
Nothing like this has been brought before the court's attention. This just came out of the blue, and now all of a sudden it's being labeled a prank. Is that because they were found out? I mean, it begs so many questions.
No, it
It's
doesn't.
too uncertain. It's too concerning, and
It really doesn't.
it's too alarming. It's too alarming to just overlook and say, "Oh well, we'll just set it to the side and let them." No, this there has to be some type of alternatives, and something has to be done.
If it turns out
Something.
that's a jury, you've got good
And
grounds
if
for
that's a
appeal.
mistrial, if that's
Now let's get on with the losing today.
discharging a jury, if that's some other type of alternatives that can be looked at, I'm sure that these case law speaks to other
What
options that could
discharging the jury
come
does
into play. They deserve to at least be looked at, if anything, to protect
looked
the
at.
integrity of the
Look
trial.
at it. You're
I
babbling
find
about
it
it
very
now.
hard to believe that this close to the trial being over, and all of a sudden these issues are being raised. So
You're the only
this
one
is
raising them.
obviously not a prank,
Mm-hmm.
and it's obvious that this is someone with intimate knowledge.
It's not obviously not a prank.
It's very clear to me.
Your trial's been
Let me address your
televised.
concerns, sir.
We've
I
seen more than
cannot
what the jury
make
has.
conclusions at this point about whether this is legitimate or a prank. What I know is as follows. I received the information about the subreddit post at approximately 9:30, 9:40 yesterday morning. I alone made the decision to withhold advising the parties because of where we were at in the trial, because there was nothing in that post. It was an anonymous post that would lend credibility to that it was in fact one of these jurors. But out of an abundance of caution, I referred it to law enforcement because it is very serious if the integrity of these proceedings were to be put at issue by a juror. I'd remind you though, every single day these jurors were read the bulk of jury instruction 50. They all took an oath, and I have no reason to doubt that they would violate that oath at this time. So I took and I made the decision to withhold telling the parties because we were in the middle of instructing the jury. I was in the middle of instructing the jury, and I wasn't going to delay the proceedings
We have
because it was so
6,500 people here
speculative
watching
at
it.
that point and remains speculative at this point. As you know, the case went to the jury. I brought this up. I waited about a half an hour once the case went to the jury. Frankly, we had had a long day. I wanted to get a bit to eat, and then I wanted to come back out and make a record of what I had. Once again, the forensic unit with the sheriff's department has taken lead of this investigation. I'm not a part of that investigation. Law enforcement will handle it. From my perspective, not only did the clerk of court's office receive emails regarding this, it sounds like the district attorney received emails. I may have even gotten one. I don't remember the time. It was later regarding the post. Frankly, people figure out my email all the time. It was not solicited by me in any way, and I did not respond to it. And I simply forwarded that email on to law enforcement. So it's pretty clear to me that a lot of people have access to Reddit.
Email her
I
the
personally
link,
am not a user
Mike.
of Reddit, so I don't know the ins and outs of it, other than it is a social media site. where people can create accounts and post, and there can be like chat rooms, for example, or just various, as this is called, subreddits. And at this point, you've requested a mistrial. You've requested that I discharge the jury. I'm declining to do that at this time, sir. Again, I need to make decisions based upon the record that's before me. And right now, the record is speculative. There are no facts to support a mistrial or discharging the jury. I trust the parties will continue in their own independent investigations, that you will continue reviewing case law, make whatever requests that you deem appropriate. I certainly will take time to look at the cases you have cited to see if there's anything based upon the requests that you have made that I would need to further review. But at this time, I do not see grounds for a mistrial. I do not see grounds to discharge the jury. That is how I will address it at this point. I know the state, I believe, wanted to address something else. I'm not sure if that was it, but you had deferred to Mr. Brooks. So go ahead. Is there anything you want me to address or at least bring to the court's attention?
Just
Grabbing
a
a
minor
law
point, Your
library
Honor,
like
you
a
had
B
noted the
student in
defendant
1L.
is in his orange jail uniform today. It's my understanding the jail did offer him the ability to put on his street clothes and he declined. So I just wanted that on the record. There may be occasions where this jury has to be brought into the courtroom for one reason or another, and he
Why?
should be in civilian clothes.
Send a note.
If that occurs, if he chooses to.
It's a good point to bring up. It is possible the jury would need to be brought out if there is any question that I need to answer on the record. If for some reason the technology were not to be working appropriately when videos or other evidence are displayed to them. And so it is possible that the jury would need to come out. Of course, they'll come out if and when a verdict is reached. So I would certainly give you the opportunity, sir, if you want to change into the street clothes, that I would certainly direct the sheriff's department to make that available for you, should you choose.
Isn't it my choice?
It
Yes.
is.
It is.
So why do I need to be in street clothes? Why does that
You don't.
need to be on the
You don't.
record? That
Your choice
If-
should be
if
placed on
or-
the record. sir.
if or
That's why.
if not, I was offered to be in street clothes. If I made it the choice,
Do you
Are we
dispute
gonna have the
that,
same
sir?
argument about
yes,
him
I
attending
dispute it
field trip
because
the other
it's
day?
my choice.
Well, no,
At
do
this
you
point-
dispute that you were
at this
given
All right,
the
I gotta go
choice
top
this
over
morning?
with legal bites,
At this
guys. I'll be
point,
back later.
There's no reason why that should be on the record. That if I was not offered street clothes, what relevancy does that have to?
Could have potential relevancy later on if
Why?
you were to challenge that you and claim that you are required to wear your jail uniform or jail attire. You're
I didn't-
not required.
I
This
didn't
is a
make that
trial. You
request.
have the right to wear street clothes, and I will certainly provide that opportunity should you wish to change at any point in time. But what you're telling me is it's your choice to be in jail attire. I'll respect that choice,
Yeah.
of course.
So why does that need to be stated for the record?
I just
Why-
indicated why, sir. So,
I
concept of
don't see the
option
relevancy of it.
all right, at this point,
never-
unless
never
there are any
raised-
further issues, I am going to go back into my office. The courtroom will remain open and we'll let you know when the jury communicates
There-
with us, either about a question or verdicts.
There is something that needs to be addressed, subject matter jurisdiction.
The
Why
court
hasn't-
declines that on second.
Why hasn't it been proven on the record yet? And
Oh.
Mhm. Okay, I'm assuming that's a yes. Okay.
Oh my lord.
Wow.
Well,
We already
You know
had more
what?
fun than I thought we would this morning.
yeah.
You and I were messaging back and forth about what to talk about, but I was going to get into the Reddit, but they already did. That was fun though.
Oh lord, he managed to soak up half an hour of people's time.
Well, here's the thing though, the jury's deliberating, right?
Yes.
Okay, so we're on concurrent time now.
Yeah.
So when he's in there running his mouth, we're getting closer to a verdict anyway.
God, I hope so.
As opposed to the last 2 weeks when he was in there running his mouth, the jury was standing around looking at the wall.
I mean, how long do you think it takes to sign 76 pages of paper?
I don't know. I put up a poll on it. I want to know, do we have any not guilties? I can't see it from the screen.
Last I saw it, you were at like 97% guilty and like 2% hung jury, which is actually about where Law and Crimes stream. They did a poll too, and they're about the same. I'm just glad that she didn't entertain him on once the second he said subject matter jurisdiction. She's like, all right, we're done. I'm going back to my office, because I'm sure she's got a ton of work that's piled up over the course of the last couple of weeks.
Oh, yeah. I mean, I do too.
Yeah, fair point.
Well, okay, no, Yeseni's done most of it, but when I say I have a ton of work, this is the standard routine. You know, you've worked in a firm, okay? So the work is I'm going back and forth, and you know, things are getting done. The ton of work will be there's a stack of things you need to there's a bigger stack of things you need to sign now.
Yeah, that generally is sort of what it comes down to.
Whereas if I wasn't bogged down with this, I would sign a small stack every day. That's the effective analogy for it, you know?
Well, when I was working in before law school, I was a paralegal at a foreclosure firm, and I might have told the story already. But I mean, we would pump through like 10 summary judgment motions a day. I would do all the work, and the attorney would just sign the papers.
Yep. That's how it's done. It's how it's been done since the beginning of time.
Oh, absolutely.
Yeah.
Our job is to talk and sign things.
What I'm doing is not anything different than some British attorney was doing to his clerk in 1834. There's no difference.
You are not wrong about that at all.
And I'm not the only one. It's the way it's done in the business.
Exactly.
I did find that interesting. That okay, so we had this, and he wants
the only attorney that drafts my own motions. I do.
Yeah, I don't do that. I mean, I'll do it. I'll say, oh, I recognize this one's weird. Give me a standard one and give it to me for a draft, and then I'll make the changes on it.
Yeah, nobody's doing it from scratch, but still.
Oh, the problem is Yeseni's been with me a long time. She's really smart, so she knows like what 80% of the obvious stuff is. And she'll do it better than me.
She sounds fantastic.
Yeah,
you're very fortunate.
I am indeed. Oh, justice for Yesenia. You said the long-suffering Yesenia lives like a queen. Are you kidding me? I mean, she's excellent, but I know it. I take care of her.
Okay. Yeah, no, he does not understand that. He does not understand the concept of you can either do something or not. It's your choice. The concept of choices is really complicated for him.
No, I thought this was really interesting, and I laughed about it. I guess it wasn't. It's minor compared to everything else that's going on. But he goes and he reads. Now he does call it the library, of course, and he does question jurisdiction. So I had to get my thinking cap out. But at the end of the day, what I found ironic about this is he sees an opportunity. It definitely is this Reddit thing. She came in and read about it in court, made a record of it. So he can exploit this and say, I don't think this trial's fair. I would too. If I'm sitting in his shoes, I would say, oh, no, this is prejudicial. And, I would make a fuss. You don't have any other arguments. No. Absolutely exploit it.
It genuinely was not. It's not a terrible argument either.
No, So to that extent, I think that was wise. He's just not very, very good at it. But he did get a little bit better. And then he goes through all this and he's like, well, this is all in the judge's discretion. Here's a guy who was in contempt of court 24/7 for the last 2 weeks. Here's a guy who
not contempt. Remember, not contempt. He was just removed.
Well, here's a guy who, to this day, even after that, questions her jurisdiction. But with respect to this, to the extent that she can call a mistrial, she's got all the discretion in the world. The irony was too good for me. It really was.
I'll just quickly give the syllabus on his 1824 case, just to point out that he got close to an argument, but was still absolutely wrong. The basic syllabus is the discharge of the jury from giving a verdict in a capital case without consent of the prisoner, the jury being unable to agree, is not a bar to subsequent trial for the same offense. So, good job. You found a case. It has nothing to do with the circumstance. And all it says is that they could retry you. So, cool.
Yeah, I might have biased my poll a little bit. I was aware.
But you know what? They still got it
I
right.
didn't give it just a generic guilty. No. I gave it a guilty of sin because that's what we're dealing with. I would, you know what? He's certainly not above cooking a Reddit post, but I don't think he's smart enough. So, as much as I would say, you know, it's not like he didn't do the Reddit thing because he has some, you know, integrity. No.
No.
It's lack of thinking of it that that makes me doubt that he's involved.
It also actually was written in, generally speaking, proper grammar.
That is another clue that. Well, he of course could have had a hand in it, but I doubt he knows anybody who speaks proper English either. If they do, they're like, "Why am I hanging out with this guy?"
Oh Lord.
Lord.
You have the photos, right?
Okay.
Let's do it. Why not?
Let me see here. If it's on Reddit, you must have clicked. Yeah. And you want to talk about a bad precedent. Everyone's always asking, does this make precedent? Okay, if he gets out because somebody makes a stray comment on social media, let me assure you, every defendant from now till the end of time will make sure that there's a stray comment made about their case on social media.
Oh yeah. No, there's no way that anyone can tolerate that.
Again, that would destroy the court system tomorrow.
Yeah. No, I mean, in civil defense, I love social media. That is one of my favorite things on earth.
Well, yeah, because defendants say stupid things. Well, the plaintiffs say stupid things too.
I had I was involved in a case where somebody claimed a workplace injury and that their back was totally destroyed, the whole 9 yards. Because anytime you investigate, this is just general knowledge for folks. Anytime you investigate somebody's spine, just as a nature of living, there's going to be slip discs and stuff. It happens. Said the back was totally destroyed. And I found after the alleged incident that they were scuba diving off of Cancun. And so we get to the deposition. The plaintiff was complaining about all of these issues and all the stuff that can't work anymore, can't carry heavy things, all of this. And you just sort of slide over the photo to the opposing counsel and be like, "Hey, do you want to have a conversation about this?" How would you handle that? I mean, I felt so bad for the counsel on the other side because it's like you're dead in the water.
How do you handle it if you're representing a plaintiff?
You settle for pennies on the dollar.
Then when you get alone with them, you say you realize you just destroyed your case. Plus, I told you not to do this because I always do. Now, I've crossed that bridge, and I'll say, what precisely do you want me to do with this case now?
Yeah. I actually felt bad for the opposing counsel. The look in his eyes when that got slid over the table, he was like, I was like, do you want me to introduce this as a deposition exhibit or are we done here?
Always good times. Always good times. All right. Let me see. Let me see who's on here. Let me see who's running around. All right, chat, you guys are going to have to help me because we're going on a field trip. That's right, we're going on a field trip.
No. I think if anything, his antics just ticked off the jury.
9 a.m. I have added in that file also the condition of no
Oh,
contact
yes.
with
Everybody-
John Arm.
Tell me if court's coming back.
Thank you very much, John.
Yeah, I'm continuing to keep an eye on it.
All right, you do say.
So for now, we're going to see one of my favorites, the Honorable Cedric J. Simpson. Show us how it's done. Over in Washington.
Yes, I did mark it.
Maybe our buddy Jessica Blanche will show up.
Yes, no, 1026. Is it? This is snowing 10.
Cedric the Goat Simpson. Cedric the Adjudicator. Let's see what he's got. We tried this the other day, and then we had the saddest call. Oh,
Here's the other.
oh, you got to smell.
Has she been? You just admitted her. Okay.
Somebody asked about medical records in a case like that. You know as well as I do, Mike, you can find a doctor to find anything, an orthopedist. So it almost doesn't matter.
Oh, it's Mr. Eighth away. Anyway.
Come on,
Court
Sid.
does call the case of the People versus Teresa Woods.
Here we go.
Conrad Silver on behalf of Pittsfield Township.
James Gallagher, Assistant Public Defender on behalf of Teresa Woods. Ms.
30, and I
Wood, good morning.
guarantee
Can you
if I
state
found a
your name
plaintiff
for the court?
out here, they would find
This is
it
live.
messed up.
Need done. Oh, there you go.
Good morning, Your Honor.
All right, state your name, please.
Teresa Woods.
All right, fantastic. Okay. Date and time set for trial. Are we ready to proceed?
Your Honor, the people are unable to proceed at this time.
Your Honor, in light of that, we respect the request that this-
Yes, I'm saying that a plaintiff's attorney can buy a doctor.
People being unable to proceed, this case is dismissed.
Thank you.
You're welcome. I don't know who the other person is, but that's your sister? Okay. You're
Yeah,
both
thank
welcome
you.
there.
Where am I on
All
this?
right, have a blessed day.
You two do the same, please.
Where's the law wizard John on this one?
Thank you, Lord.
Judge.
You knew a thank you, Jesus was coming out, right? All right. 14H stands adjourned. Why is this?
Too much at the door. Can you push it to the right?
The legend still survives. She may still be out there somewhere, trying to parallel park.
I don't know where she is right now. Where Janelle?
I haven't seen her back at all.
That she's got to learn how to parallel park. I gotta have a party stream when it happens.
That would be fantastic.
Oh, all right. So did I miss anything? I mean, I went on at 8:30, but did they bring the jury in at all this morning that I missed?
No, they did not.
It doesn't make sense that they really need to. I mean, they bring the jury in, but then they go into the jury room and start deliberating. The end.
Yeah, I don't think they brought them to the courtroom at all. Otherwise, he wouldn't have had put on the record that he was offered street clothes in case the jury needed to be brought through.
Yeah. Oh,
This is the worst part. It's waiting for the jury to come back.
When you try a case, this is the worst.
Yeah.
Because even if you're in the middle of the boring parts and the trial's progressing, you have a next thing to prepare for.
Right.
A next
I mean, this
argument after you deliver your clothes, then there you are.
Yeah, basically you go out to lunch and you pray that you get a text sooner rather than later before your brain explodes.
Yeah, then you're effectively on a tether because if the judge needs something or if the jury asks a question, they need to get a hold of you.
Yep. So you got to
You
stay
can't
with
really
it.
go
and
anywhere or
short.
do anything.
It's not like depending upon, what court you're in, it's not like you can go back to your office or anything. So you go find a coffee shop or somebody.
I go back to my office. I go back to my office, but I'm in downtown Chicago. And my office has always been within a block or two of the courthouse, and you just
well, you're luckier than most. I mean, I've had ones where it's an hour and a half away from my office, so it's not like I can go anywhere.
Yeah. Or if it's out of county, then there you are.
Yeah, exactly.
Then you're stuck at some,
you
in your
find a
car or
shop
at
or
a
a
restaurant.
restaurant.
It's not luxury. It's not a sexy occupation. I don't know what to tell you people.
Some courts have fairly nice lawyers' lounges. That's sometimes nice. I don't know how they do it over with you, but there are courthouses in New York that have some nice lawyers' lounges. So you pull out a laptop and you try and get some work done while you're freaking out in the back of your mind on what the verdict's going to be.
John, I want you to handle this one. We want to recap, and don't forget the jurisdiction got raised. Okay.
Yes. So we began with the Reddit post, and that was a glorious nightmare where he is deeply concerned and made sure that everybody knew that multiple times. The judge, he decided to cite 3 cases, none of which were on point, but were almost. I'll give him that. The judge ultimately denied any sort of mistrial or to discharge the jury, which is basically either the functional equivalent of a mistrial. So that's great. Then the prosecution wanted to put on the record that he chose not to wear street clothes today. He was given the option, but chose not to. So he decided to show up in his orange jumpsuit. And then once that was done, he started talking about subject matter jurisdiction. In about 5 seconds, the judge decided to leave the bench and try to catch up on all of the stuff that she wasn't getting to while she was dealing with him for the last several weeks. Is that about fair update?
That about covers it. We actually got more. I'm like, okay, so this is super interesting. And now it's like, I've been doing this for so long. We did the Summers case, Deputy Heard. I've done a bunch on Blandino. I was there when the verdict was read on that. I can't believe it. I've now done a lot of I tend to just do interesting cases from the day, smaller clips.
Right.
But every once in a while, something comes along and I think, okay, I'll follow this thing.
I enjoy
I never want to because it's so much, but then it is
time consuming. But I think once you got hooked on this one, once I got you to do the second day, we were just going. It was going to happen.
And I never thought this case would be boring, and it wasn't. But I just didn't want. The last day when they did the prosecution did nice. It wasn't as bad as I thought because she kept it short and did a damn good job in my opinion.
I agree entirely.
His closing was shorter than I thought it would be. But still, you're sitting there confronted with the reality of the case, which you knew the whole time.
Right.
And it's just it's a downer. I don't know what to say. It's just a terrible thing.
Which was worse, Summers' case or this case?
Oh, this case by far. She lived.
She lived. That's fair, but to some extent, I think the personal nature of that one, is really tough as well.
That was really tough. Kids having to testify against their father.
Right.
I mean, he brought this all on, and it's disgusting. But that was hard.
I think that's why. I think that they're both awful. Obviously, in terms of total body count, life and limb, this one's worse. But I think the emotional aspect of Summers was really
rough. Case was really neat because you were got into the courtroom live.
Yeah.
And then we got to know Elisa herself, and she came on a stream with us. That was really, really cool.
I think the one thing where I'm going to say that this one's worse is Elisa did an amazing job bouncing back, and her kids are fantastic, such cool people. And so to some extent, it makes it more heartbreaking because they're such great folks, but they seem like they're getting on well. She seems really happy now. So that's what, I
mean,
don't know. I
got
hate to say
meet
it's like a
them live
silver,
in person.
it's not a silver lining, but it's sort of, it's at least, it seems like it ended in.
I intentionally skipped portions of this trial, and I'm glad I did. And they needed to be done, and they're all appropriate. But I just didn't want to sit there in the early middle of this trial.
Yeah.
And I know what happened, and just relive that,
Yeah, everyone knows what happened, and somebody this morning was saying that she had just seen the video of the actual car coming through the parade, and it's like, I don't know if I would want to watch that.
Yep. That, well, I know you're aware that right there is the death penalty.
She said she only killed 3 cones last time.
Right. That one is so fun, and it's sort of the opposite sort of scenario of this. The judge does want her to get her license back. No one's getting hurt. It's charming that she can't parallel park. It's the absolute opposite of the Brooks case.
Oh, yeah. Well, and I just, the thing that really gets to me with Brooks is just the imperiousness and the utter lack of remorse. I mean, sentencing is going to be a nightmare because there's going to be no remorse. There's not going to be a shred of him actually taking responsibility for his behavior.
Nope.
And he's going to get the max. I almost guarantee you, whatever they find guilty on, they're going to throw the book at him. And they should.
And they damn well should.
Like I said, I think that he should just be locked in a room for 20 minutes with the family members, and whatever happens, happens.
Oh, wait a second. Oh, it can't be. Wait, John. You're going to like this. You're going to like this.
What do we got?
I got a special treat for you.
Oh, Judge Manning's on. Is that what this is?
Break trial.
Let's do it.
Let's see what's happening over at Judge Manning's courtroom.
And get back started in once again, if everybody could attorneys just state their name for Ms. Sanders, because she says she may not be so familiar with some of the lawyers that are on here today. What y'all do, we can get started if everyone's ready.
Good morning, Ms. Sanders. Adam Abadi for the state.
Don't let me forget about the other trial, because I'll get into this.
And good morning, Ms. Sanders.
I've got it on my phone. I'm waiting to hear for it to come back.
G is and Gerald, O is and Oscar, U is and Ursula, D is and David, I is and Yolanda. I couldn't hear the rest of what you said. I heard G, O, and then it got muffled. Could you please? So G, O, U is and Ursula, D is and David, Y as in Yolanda, Dowdy. Okay. Is she here now?
I guess it's a new court reporter.
Yes, you can just spell it out without using it gets muffled. It's Goudy. Is that better? Yes. Okay, thank you.
All right. Is everyone ready?
Yes, Your Honor.
All right. Go ahead, Mr. Body.
State would call Detective Savannah Berry.
Oh, good Lord. We don't know what's going on, but I promise you it's likely to be delicious.
I think we got a full-blown trial.
Savannah Berry, SAVANNAHBERRY.
Thank you, Detective. That microphone doesn't have to be pulled right up to you. If it does, it makes it real complicated. I mean, not so far away, but yeah, you don't have to be right up at it. Should be able to hear you. You just keep your eye on the court reporter here in the black blouse with the kind of wooden slats behind her. On the screen. Oh, she can't see the screen. Mr. Abadi, if either one of you see Miss Sanders kind of waving her hands, you'll know that she can't hear.
Okay.
You see the court reporter? Okay. Go ahead,
Okay.
Mr.
Oh, sweet Georgia.
Good morning, Detective Berry.
Good morning.
Can you tell the court how you are currently employed?
With the City of Atlanta Police Department Homicide Unit.
And how long have you been employed, one with the City of Atlanta Police Department?
Almost 10 years.
And how long have you been assigned to the homicide unit?
Almost 4 years.
Okay. And can you tell the court how you became the lead detective for an incident that occurred on June 2nd of 2022?
Yes, I was called in that evening of June 2nd, 2022 to come and respond to 840 Humphrey Street. It was just my turn to take that very next
try
case,
driving in
and
New York.
upon that call, I arrived
You
on
need to
scene.
go to Parallel Park. I don't remember
And
where she is.
you said 840 Humphrey Street.
540.
540 Humphrey Street?
Yes, which are our apartment complex there in Mechanicsville.
Okay, and is that here in Fulton County?
Yes.
Okay. Now, can you tell the court, you said you were dispatched to 540 Humphrey Street for what purpose?
To respond to a person shot and unresponsive. He was, the decedent was transported to Grady Hospital at that location where he was pronounced deceased. And at that time was when I was called out to investigate this homicide.
And can you tell the court about what time, I guess the 911 call was received and about what time you were able to get to the location?
I'm not accurate on the time of the 911 call. I respond on scene at about 9 p.m., 9:30 p.m.
Okay. And when you arrive on scene, are you the first person on scene, or are there other officers and detectives who have already arrived?
Yes, there were other officers and detectives on scene.
Okay. And prior to, I guess, you beginning your part of the investigation, did you speak to those officers and detectives to get a bearing of what they first encountered when they arrived?
Yes, sir.
And in addition to the officers and other detectives in your unit that were present, were there any witnesses on scene that had witnessed the shooting?
Well, upon my arrival, what I was able to, the information I was given from other investigators were that had surveillance cameras, as well as potential witness, which would be the best friend from what I was told of the decedent. His name is Mr. Tucker. Mr. Tucker was on scene, however.
Barry, I'm sorry, you were speaking a little bit too quick. Could you go back to until you spoke to the initial investigator?
Okay. And had one investigator that was looking at
I saw
surveillance.
that the witness is standing.
Another had interviewed who I understand is the best friend of the decedent. Upon my arrival, that particular witness who was with the decedent left the scene. His aunt was still there on scene, who just advised that her nephew did not want to speak. Other witnesses.
Were you able to identify who the decedent was?
Yes,
And who was
yes.
the
The
decedent?
decedent, 17-year-old Dravion Dre Matthews.
Okay. And you said the best friend of the decedent, Mr.
17-year-old
Tucker,
shot and killed.
his aunt was on scene and she advised you that he was there but didn't want to speak to you at that time.
Correct, but he did give a statement to one of the investigators who were there initially.
Okay.
His statement didn't give much information. Again, the decedent's best friend. However, there were other witnesses who came forth and told me specifically to speak into, to look into the particular defendant who's here today, who goes by the nickname of Rock.
And through your investigation, when you initially received the nickname of Rock, were you able to identify Rock's birth name or legal name?
Yes, I was.
And can you tell the court what is that, or what was his identity?
It's Roderick Teasley.
Okay. And you said there was an investigator who was first looking or investigating as to whether there was video surveillance.
That's correct.
And were you and your investigative team able to find video surveillance?
Yes, sir.
And can you tell the court, upon finding and reviewing the video surveillance, was the defendant on or captured on the video surveillance?
Yes, sir.
And can you tell the court what you saw the defendant doing on that video surveillance right after the shooting?
Yes, 10 seconds after the shooting was where I was able to see the defendant with a handgun in his hand.
I have a comment on that, but I really should not say.
And can you tell the court in the video surveillance, do you see the defendant doing anything else within the video surveillance that you viewed?
No, sir.
Okay. And did the video surveillance that you were able to locate and collect, was the shooting included on it?
No, sir.
Okay. And was the shooting outside, I guess, the purview of the cameras?
It was directly outside of the building, of which I was able to see Mr. Teasley on camera with that handgun.
Okay. And can you tell the court how far is the building that you see the defendant
Yards.
handgun?
I understand. No more than 15 yards.
Now, in your review of the video surveillance, are you also able to see other witnesses that were close to the scene?
Yes, yes, I was.
And were you able to identify any of those witnesses?
Yes.
And can you tell the court who you were able to identify?
I was able to identify Antonio Dixon, his brother Jabari Dixon. Those are the two that I knew by name who witnessed this particular incident.
And were they on scene when you arrived that evening or no?
No, sir.
Okay. And as you are at the scene investigating and processing it, were any shell casings or any other ballistic evidence found on scene?
Yes.
Okay, can you tell the court if you can recall what ballistics evidence was recovered?
Not able to say which caliber and how many there were, but I can say that they were shot from the same weapon.
You can say they were shot from the same weapon?
From the same weapon.
So based on your investigation, only one firearm was used in the shooting killing of Mr. Matthew.
That's correct.
Oh, this one's for real. We got us a heater.
Yeah.
Now, upon identifying both Mr. Antonio and Jabari Dixon, can you tell the court kind of what your next steps were?
Well, they were not willing to speak with me. It was not until Mr. Dixon, but Jabari Dixon was placed in custody at the same time as Mr. Teasley the same morning. And upon Mirandizing that subject for a different case, an unrelated case, was when he was able to tell me that he did see the defendant shoot and kill Mr. Matthews.
Okay. So when Jabari Dixon was arrested and Mirandized, you spoke to him, and not about his case, but about this unrelated case.
That's correct.
To his arrest. And during that interview with Mr. Dixon, he told you he actually saw the defendant, Roger Teasley, shoot and kill Mr. Matthew?
That's correct.
Okay. Now, you said that on that same day, the defendant was also arrested by fugitive?
That's correct.
Okay. And upon his arrest, did you have an opportunity to speak with him?
Yes.
And prior to speaking with him, did you advise him of his Miranda rights?
Yes.
And after advising him of each of the rights he'd be waiving, if he agreed to speak with you, did he waive those rights?
He did.
Okay. And upon his waiver of those rights, did you then begin your interview with the defendant?
Yes, sir.
And can you tell the court what, if anything, the defendant told you during that interview?
Yes, sir. Now, that was not my first interview with Mr. Teasley.
Okay.
My very first interview with Mr. Teasley, we met and he let me know that he was out of town. He was in California. The second time we spoke, he was on the way to California, approaching Texas at the time of the shooting. And then the third time we spoke, I believe it was the time when you're asking about, when I Mirandized him, he was in custody, was when he did admit that he was there on scene. He heard the altercation between the decedent and some other people he advised. He was very adamant that he did not have a gun at all. He doesn't have a gun. After showing him that I see him with the gun, then he advised, well, if I did have a gun, it would be my child's mother's gun. His child's mother is the one who lives in the particular building just yards away from where this incident happened. And at which time he stated that his brother did come on scene. He did hear gunshots. He pulled out the gun just for protection. And that was his statement.
Okay. And just so it's clear for the court and for the record, prior to Mr. Teasley's arrest, you spoke with him 2 other times when he was not in custody.
That's correct.
And that would have been closer in time to when the shooting occurred, correct?
That's correct.
And during your first encounter, was it over the phone or in person?
Each were in person.
Okay. And the first in-person non-custodial, I guess, interaction you had with the defendant, he told you he was in California at the time of the shooting.
That's correct.
Despite him being on video.
That is correct. I didn't tell him about the video. On that first interview, when he left, I showed him a picture of a still shot with him being on that surveillance footage. I was able to crop out the handgun. And he confirmed that it was him at that time.
And then close in time, I guess, to that first initial encounter, you had a second in-person encounter?
That's correct.
And during that encounter or conversation, he again told you he was in Texas, but on his way to California, despite him seeing the photo of him on scene.
That is correct.
Okay. And then he was arrested on, looks like July 7th of 2022.
Yes,
And after Mirandizing him, he again agreed to speak with you.
yes.
And that's when he told you that he was on scene, but didn't have a gun.
Right.
And you said you showed him the photograph of him actually holding the gun 10 seconds
Same,
after
yeah.
the shooting.
It's the same photograph that I gave him at first, but without the cropping and the editing.
Okay. And do you see the defendant, Roderick Teasley, here in the courtroom today?
Yes, sir.
And
Sitting in between these two females with the blue jumpsuit.
Okay. Your Honor, let the record reflect that the witness has identified the defendant.
All right, noted.
She sure has.
And Your Honor, I don't believe I have any further questions for Detective Barry. Thank you.
All right, Cross.
Good morning. Can you hear me okay?
Yes, thank you.
And Ms. Sanders, can you also hear me okay?
This could actually
You
be
can speak up just a little bit into the mic.
All right, can you hear me better? I don't want to disrupt the mic.
Now we get to actually see.
All
it
right, so Detective Barry, good morning.
Good morning.
Besides yourself, who else responded on the night of June 2nd?
Initially, because the decedent didn't pass immediately, it was actually the aggravated assault team who responded after the Zone 3 units responded to the actual 911 call of some person shot.
And do you know approximately how many officers responded on June 2nd?
The Zone 3 units, approximately 5.
And I'm assuming these officers had on body
There
camera
is.
upon arrival,
Yes, ma'am.
and they were wearing that body camera upon arrival,
Yes, ma'am.
and that's all been preserved and recorded for later review?
Yes, ma'am.
Okay. Now, you said that upon arrival, there were multiple investigators present,
Yes, yes.
and you said that one in particular was speaking
It is.
to the aunt of a juvenile,
The
Yes.
mods, please take care of
and then
it.
there was another investigator
I don't know.
trying to work to secure whatever surveillance footage existed at the property.
Yes, ma'am.
Okay. Now, do you know the name of the actual apartments where this took place?
The Mechanicsville apartments consist of 4 properties. I can't remember the name of this one. I want to say Central Station, but I'm not sure.
Oh, understood. So the investigator that is speaking to Aunt, you have that individual's name?
Yes, Detective Malone. He would be the same investigator who actually spoke with Mr. Tucker.
Okay. Now, what was Mr. Tucker's first name?
He gave me a false name he gave us a false name that night, but it's actually Xavier Tucker.
You have a spelling of that name?
Sure. ZAVION TUCKER.
And what was his age at the time of the conversation?
I'm not sure of his age at that time.
I would, but they'd
There was a
copyright me.
need to have the aunt present because of his age, or is it that she just felt more comfortable because?
She lived there. She was just being an auntie. It wasn't a need to answer your question.
Okay.
They're going to
Detective
copyright you
Malone
from jail.
Would Detective Malone have a conversation with Xavier Tucker?
Yes.
And to your understanding, what did Mr. Tucker tell him?
I just recall that it was any pertinent information. He was attempting to get away from the conversation, but I didn't receive any good facts, honestly, from that particular interview. I can't recall exactly what he shared at that time.
And then after speaking to Mr. Tucker, he said that Mr. Malone also spoke to Mr. Tucker's aunt.
Yes.
And what was the aunt's first name?
I don't recall. I don't recall her name.
And what, if anything, did Ms. Tucker say to Mr. Malone?
That he's not here. We were just looking to do a follow-up because I had arrived on scene to speak with him. So she just advised that he's gone.
And did she advise why Mr. Tucker had left the scene?
No.
Okay. So besides Mr. Malone speaking to Mr. Tucker and Ms. Tucker, did Detective Malone speak to anyone else?
Not that I'm aware of.
Okay. So you said that there was a second investigator who was looking around the property to see if there was any surveillance, correct?
Yes, not necessarily looking around the property. They have actual security guards there, so they were just working with them to extract and take a look at what we had.
Okay.
Mhm.
Now, were you able to canvass the area yourself personally?
Yes, I was.
Okay. And so to my understanding, this apartment complex has cameras in the hallways of the building, correct?
Yes.
And there are also cameras in the parking lot as well. They're attached to kind of like a light pole sorts.
Yes.
Are there any cameras that are attached to the outside of the buildings?
Yes.
Okay,
Are you asking directly on the buildings?
exactly.
Well, yes, because there's footage where I can see like the breezeway of the decedent's apartment. So yes.
Okay. And
Can
so,
I get your
how many
question?
cameras did you
I'll
all
answer when there's a
extract
break.
footage?
We extract from all cameras. As far as how many that is, maybe 15, 20.
And so these cameras that you all are extracting footage from, they are depicting what took place inside the corridors of the buildings, outside the parking lot, more generally as well.
Yes,
Okay.
breezeways, parking lots, hallways inside the buildings. Yes, ma'am.
Okay, so multiple vantage points these cameras are capturing.
Yes, ma'am.
Okay.
It also has actual LPR, which is a
It's
license
only
plate
been an
reader.
hour. They've
So
had a
all
lot
the
of
cars
paper to
that
get
come
through.
in and come out, there's actually a good camera that shows the tag of these
I don't
vehicles.
think so, but
Now, besides
who knows?
covering the footage from the actual inside of the building, outside of the building, did Detective Malone speak to anyone else in regards to this incident?
Again, not that I'm aware of.
Okay. So did Detective Malone or the other individual have an opportunity to review
That's
footage
one thing
on
that's
scene?
nerve-wracking
Yes.
Okay.
about waiting for
And
a
did that
jury
footage
in some
on
of your
scene
cases.
display
You just
how
have
many
no
people
idea.
generally were outside that?
No, because just with all the cameras that were there, what I still do not have is the actual shooting incident. So speaking with other witnesses are consistent with saying there were a group of people outside arguing, whereas I can't see that with the cameras.
Okay, so in speaking to this group of these individual witnesses, did they say how many parties approximately were outside that?
Yes, as far as all the folks that I spoke with, it was a range between about 5 to 15 people.
And did they explain kind of the genders of these individuals,
No,
the general age range of the individuals?
young.
So they said like approximately all the 5 to 15 were all young males.
They just said young, and then there was a particular
basically, long
witness
story short,
who I'm
it's a
thinking about
hoax.
right
It was
now
a
who was
joke,
able actually to
and he made a big
identify
deal
him
about it
by
this
his
morning, but
nickname.
it's not- it was a
And so it was him as an older person, and then everyone else is young. That's what I'm hearing.
And did the witnesses say they were all having a conversation with each other that night?
An argument.
Argument.
Yes.
So they said that all 5 parties, all 5 to 15 parties were arguing with each other.
No, they said the argument ensued between the decedent and the defendant.
Okay.
It was just other people there. And again, the cameras doesn't show like a group of people just standing around though, but consistent from witness statements, group of people there. But everyone wasn't involved in the verbal altercation.
Okay. Now, where exactly is this argument taking place?
Karen, they're all in the same
There were
courtroom.
2 that happened on this particular day. One was early in the day, right outside of the decedent's apartment in the breezeway. And again, you can actually see this. I was told that there had been issues between management, like the apartment management and the decedent's apartment, which is under his mother's name, where there was a lot of people that would congregate outside of their apartment. So his mother, the decedent's mother, would enforce the fact that people can't stay here because they're threatening to kick us out. Therefore, the decedent earlier that day had to say some words to some people, which included the defendant to leave the breezeway because, you know, he doesn't want to have any issues with the management. That was an altercation that came and went. And then hours later was when there was the second altercation. I'm sorry, what was your actual question about? Like, where was it in the parking lot?
Correct.
If you come into the apartment complex that come in through the gate, you come in and there's a short distance before you get your first stop sign. It happens right before you hit that stop sign on the sidewalk.
And that smaller kind of corridor is between 2 actual buildings.
That is correct.
Okay. And so if you come in through the gate, it's my understanding, Mr. Matthews and his family live in the building to the left.
To the left, as soon as you come in, that's correct.
And to the right is Mr. Teasley.
That's correct.
Okay. So you're saying part of the argument took place in that area of the parking lot.
That's correct.
Okay. Now, when you said that the shooting itself took place outside of the view or camera footage, it's not in that particular parking lot that we're speaking.
Yeah, that's where it happened.
So the shooting took place in that particular parking lot.
Right there in the sidewalk. It's not going to be in the actual driveway, but on the
Murder trial
sidewalk where
in
you
front of
come
Judge
in,
Manning.
right there to the right.
Okay. And are you saying that it's outside of the
Fresh content
view
while you wait.
cameras that are
Let's
inside
talk
the
with Mike,
hallway
yeah.
of that building?
All cameras.
Okay, okay, okay. So far we have that there are 5 to 10 young witnesses, a variety of kind of conversations going on at some point, mainly between the decedent and Mr. Matthews. Is that correct?
Mr. Matthews and the defendant. Yes, ma'am.
Mr. Matthews and Mr. Matthews. Okay. And are all 5 witnesses saying this independent of each other?
The 5 witnesses were given to me by other witnesses. I wasn't able to speak with any of those on-scene witnesses besides Jabari Dixon, who was placed in custody the same day as Mr. Teasley.
Could you repeat that last statement for me?
Sure. The 5 people, I weren't able to speak with them. The only folks I was able to speak with is Mr. Jabari Dixon.
Okay. So you say you spoke to Mr. Jabari Dixon after you had him in custody.
He was
right?
placed in custody.
So
yes.
besides Mr. Dixon, again, we know that there are upwards of 4 to 14 other individuals outside that night. And to your understanding, did law enforcement have the opportunity to speak to all of those individuals?
Yes.
Okay.
Refused to
And
speak with us.
the ones that did actually allow you all to speak.
That's correct.
Okay. And so are the parties separated from each other while these conversations are taking place?
Yes.
Okay. And I'm presuming that this information would also be captured on body camera as well.
Or just regular surveillance or audio footage. Yes.
Okay. And during each of the conversations with each of the young males separately, are all of them saying that there is an argumentative conversation stored between Mr. Teasley, the defendant, and the decedent, Mr. Matthews?
Yes, ma'am.
Okay. So besides kind of those conversations and the footage you're able to kind of capture from inside the building, camera footage that's attached to the building, are there any type of shot spotter technology in the area?
No, ma'am.
Guys, I literally have Court TV on my phone right now. Nothing's in yet.
And so on camera footage, you said that 10 seconds after the fact, you saw Mr.
I love
Teasley
Judge Manning, but this one's pretty heavy.
Okay. So
Yeah.
before the
We're
shooting,
gonna have a
did you
vote.
see Mr. Teasley outside?
One to stay here.
And so
or two
it's
to
not a
head to the
situation where you
36th
don't see him
district
coming from
with Lanice
any of
Bryant.
the buildings to the left of
Tell
Mr.
me in the
Matthews
chat.
live.
No. The only time I see him near Mr. Matthews' building was during the altercation that happened earlier that day, which was hours before the shooting.
And you don't see him coming out of the building on the right where his girlfriend used to love or his family lived.
Only time I see him is 10 seconds after the shooting with the gun in his hand.
It's
In reference to the actual shooting.
All right. But do you
they should say a whole thing, but let's put senior and then let's maybe put that picture. So you might need to keep a picture of your daddy with you so you can show the people, no, that's my daddy. Okay, let's give him December. Just put him on not December. Put him on November the
Guys, where are you getting that?
I know what you're saying.
Put him on November 29th. Tell your daddy he has an arraignment on November 29th, Judge Bryant on this same Zoom court, and see if he show up, okay?
Okay, I'm assuming that's a yes. Okay.
Yeah, my dad, he probably haven't taken care of this because he right now currently going through dialysis and
okay.
having problems with his kidney failing and stuff, so he got to go to dialysis three times
Does he
a week.
go? What days of the week does he go to dialysis?
I'm not sure.
Okay, usually it's like Monday and Wednesday and Friday. Okay, well just tell him to come on here, and Mr. Waukesha has a good heart, and if he could prove that he's going through dialysis, maybe the prosecutor will dismiss the case and he won't have to come to court and get his son arrested for a gambling case. Okay.
I'm about to call him when I get off here.
Yeah. Okay. All right. Sorry for the inconvenience to you, Mr. Eatman. All right.
All right.
Okay. You have a great day. Stay safe.
You too.
All right. Arresting the wrong people out here. What y'all doing? Mr. Wakula, you shame. That was the state police probably. No, because he was at the DDC. Who is getting arrested on a gambling case and going to jail?
To be fair, Mr. Eatman Sr., according to the police report, has
some other cases.
Numerous other warrants out.
Okay.
So
okay, well, he's going through dialysis. He don't care about this gambling. All right, thank you, Mr. Wakula. That concludes your matters.
If there's an October greatest hits on YouTube, I think that one might.
It might make it. It might make it. It might make it. All right. Have a great day. Stay safe.
Okay, I will. Bye, Miss Stevenson. And Miss Stevenson, to answer your question really quickly, because I'm not going to put it in the chat because we're not getting involved.
Right,
I don't believe so. No.
The local Milwaukee station. They say.
I think I banned the chat anyway because the people was chatting to me this morning.
I figured.
Yeah, the chat, it was disabled. They chatting to me this morning. It's just out of control. Okay.
Okay. Thank you, Your Honor. Have a good day.
All right, you too. I am going to be ready on render. However, before I do render, I kept Miss Newburn on the screen because her case was slated to be adjourned by me because the court has a noon appointment that I have to make. However, I'm looking at
that's at least what local news is reporting.
The email that I received, and it appears, and just for the record, this is case number 224410801. This is the People versus Alice Newburn, and she's charged with retail fraud. Today is a day set for her review. Ms. Stevenson, your appearance, please.
Thank you, Your Honor. Janice Stevenson, appearing on behalf of Ms. Alice Newburn. Ms. Newburn, ma'am, good morning. Please unmute and tell the judge your full name.
Ms. Newburn, where did she go? Oh, unmute, ma'am. You haven't moved. Unmute.
We get it, guys.
All right, state your name.
My name is Alice Newburn.
Okay, so it appears that she has completed all the terms and conditions of her probation except clearing up a warrant. Did she clear up that warrant? She has a warrant according to Miss Brimage. She has done everything she's supposed to do except she still has a warrant in Highland Park.
Permission to speak, Your Honor.
Oh, Mr. Bird, you were the one that spoke to her?
Yes, Your Honor.
I apologize. I forgot, Mr. Bird. Ms. Stevenson, she just put her appearance on the record. She's
doing what I'm told.
She could have said Mr. Bird was handled the case. Right, because I was gonna say, now don't act like you do what you told. Mr. Bird, yes, you may. Put your appearance on the record, Mr. Bird.
Yes, Your Honor. Brandon Bird on behalf of Alice Newburn, PA 3734.
The client just put her appearance on the
record.
record.
She did have a ticket that she was supposed to take care of in Highland Park, which she has been trying to take care of. She called Highland Park twice, had somebody to try and take her to the courthouse. Unfortunately, they couldn't find the courthouse, but she's prepared to pay today. She even tried to pay 36, but of course 36 couldn't take her payment for a Highland Park issue. So she was told over the phone from Highland Park that it was going to be a couple weeks before she got a message back. Before she got something that tells her how to pay. So all she does is need to know how to pay, but she's prepared to pay. She's prepared to take care of that matter.
When you said they couldn't find the courthouse in Highland Park that sits right on Woodward. It faces right, it's Woodward, and it faces Woodward, and it's right there. Okay, so that confused me, but also you confused me because according to
I wonder if the verdict might be in, Mike.
my records, she has a zero balance with
Yes, we
36
get
District
it.
Court.
Right. It's not that she tried to pay the Highland Park ticket.
Oh, yeah.
At 36 because she couldn't find the courthouse. Like she explained to me that it's on Woodward in California. And
It's right there it's that building. I mean, they don't have a big old sign, but all right. So listen, she was charged with retail fraud. She completed the terms and conditions of her probation, except that Highland Park warrant. I'm going to go ahead and close her out and honor the delayed sentence. I believe this is a delayed sentence. I believe. It's not on a delayed sentence probation order. But it's retail fraud, so I don't know why it wouldn't be a delayed sentence. And I'm gonna close it with improvement, even though that warrant is still outstanding at the 30th District Court. Ma'am, you have a warrant for your arrest at 30th District Court, and so you need to figure out how to handle that, and not let it linger out there. Okay?
Yes, ma'am.
All right, Ms. Newborn, we're gonna mail you a copy of the order of dismissal and discharge for your records. Have a great day. Stay safe.
You too. Thank you, Your Honor. Have a great day.
All right.
Thank you, Your Honor.
Bye-bye.
Bye. I'm ready on render. This is case number 204531601, the people of the state of Michigan versus Damian Darrell Render. The defendant is charged with 1 count of operating while intoxicated, 1 count of guns possession under the influence. Today is the day set for final pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
May it please the court, Judge Adam Clements appearing on behalf of the defendant. Sir, would you state your name for the record, please?
Oh, there you go.
Damian Render.
Mr. Render, do you have a middle name?
Oh, Damian Darnell Render.
Thank you, sir. Today is the day set for final pretrial conference, and the matter is on the court's docket for 9/16, indicating that it was awaiting a jury trial date. Mr. Clements, how are we proceeding?
Judge, can we come back in 2 weeks to resolve the case?
If you call the legislature and say, give Judge Bryant some help, then you can come back in 2 weeks. But if you don't, and they don't, no, you can't come back in 2 weeks because my docket is full. But you can come back.
Because we wouldn't be able to look at a jury trial in this matter until 2023. And is that correct?
That's correct, but I do have some new jury trial dates. And so whereas you would have been looking at the end of 2023, now you're looking at more closer to the beginning to the middle of 2023. Mr. Tuttle, call the courtroom. Mr. Tuttle said he was gonna check in to see what happened with his client. He calling me on my cell phone. That don't make no sense. He's great. He's great. So in transparency, so now I'm able to do jury trials every week. Do I want to do that? No, but I'm going to do it to catch up. So I have some jury trial dates that will be earlier than next October. Now it would be like next April, March, April, or May, depending on something like that. So that just depends on what you want to do, Mr. Clements.
We can set it for April, but I'm going to get with Ms. Ritter. We're going to look to bring some finality to the case.
And so if I set it for April, you want to, I'm not pressuring you to put it on a jury trial docket, because once I vet everything, I'll have some dates for you. But did you want another final pretrial date so you could see if you could work it out? And then
Sure,
I can put you on it. Okay. So, and great morning. All right.
Okay.
I am Judge Lanice Bryant. Welcome to the 36th District Court. You are at the 36th District Court. You are at 36th District Court. You are at 36th.
Where are we, Judge?
Court. You are at 36th District Court. This is phone number.
No, Judge, can you send it to me, please?
Yes. Mr. Clements, I could put you probably that first week in December. The end of November, first week of December.
No, most certainly not.
Maybe December 2nd?
That's fine.
All right. I'll put it at 9/16 again, that same date. That lets me, that same time, that lets me know it's waiting, it needs a jury trial date. And then I'll for sure be able to tell you, I shouldn't say that, because I'm bringing people in early for their pre-trials to see if the people who are later in the year want to move their trial dates up. If they do, I'm going to give them priority for those first new dates that I have.
Okay.
All right, so I'll see you December 2nd at 9:16.
Okay, very good, Judge.
All right.
Mr. Render, give me a call.
All righty.
Thank you.
Okay, then everybody have a great day. Stay safe. Bond will continue. Okay, let me send this to Miss Muldrow. Because that is really funny to me. So, Miss Muldrow, let him know.
If you're a pharmacist, why in God's name would you want
Miss
to get a
Muldrow, let me
JP?
call you. Let me call you, Miss Muldrow. Mr. Lane has popped up on my screen without a plus sign. I don't know what that means. Miss Muldrow, I'm going to call you. I'm going to mute myself.
Oh, Halloween is too perfect if that's the sentencing.
That's a good question. I could see that. I could see them just finding something and like kicking out one count some here or there. But it won't matter.
I mean, as long as the top 6 are guilty, he's done anyway.
All right. Miss Stevenson, there are a couple of people, I think 3 people in person. With respect to those in persons, are you ready to proceed or do you need anyone to call you?
I am ready on Ms. Miles. I think Ms. Young is slated for an adjournment, and I don't know the third person.
Let me go to my message from Ms. Muldrow. Yeah. Oh, Little.
Davis, that is my expectation, but you never know.
Oh, Haida.
Okay.
And she was slated for an adjournment too.
Okay.
But it looks like I might be able to do it without adjourning. So, I mean, we're moving pretty swiftly. Let's see where we are in 30 minutes, and then I'll tell you if they actually need to be adjourned.
Okay, but I'm definitely ready on Miles, which I think there's a complainant here on that.
All right. Is there a complainant on Miles? There's a complainant on
Already been there,
Neves.
Griggsy.
Is Neves ready?
Neves is ready, Your Honor.
Neves.
People are ready on Nevis, Judge, and Miles. Both have complaining witnesses.
Where's the complaining witness on Miles?
I just brought her in, Judge. She must have left, so I'm just gonna rename her again.
Oh, yeah, she left. Okay, well, I'm gonna do Nevis first if Nevis comes to their video. And then I'll do Miles. All right, this is case number.
Well, we don't have any action at the moment. My green screen's messed up for some reason. Let me see if I can fix that. This is very exciting. We're well aware. They're supposed to read the verdict at 10:45. We'll head over there before that, so we can experience this one together. We just hopped on and saw Judge Manning. Although Judge Manning had a serious murder case going, it was interesting. But we went over to Lanice Bryant's room because we wanted it a little lighter. She's more in the middle of a call. And that's just what we were doing. while we were on verdict watch, let me go. Let me see if she's back. Thank you. You guys are the best. My only question is he going to raise jurisdiction?
Oh, how long do you think while she's trying to read the verdict before he gets thrown out?
She does not want to throw him out. Yeah, he'll deserve to be thrown out, but I don't think he gets there. I don't know why. I don't have volume on that. I don't know what I'm doing wrong here.
Do you think while they're reading that he's guilty on everything, he's going to be able to shut up? I mean,
I don't know if he'll do
Mr.
that.
Gaston, please remain stationary. Your case is being called in a minute.
I don't know if he'll. You know who?
Thank you.
Who sat there and took
Yes,
it?
ma'am. I was just cutting the
Trevor
light on.
Summers.
That's true.
He just stood there stoically while they said you're guilty on everything you did, which he was.
Yeah.
And he just stood there and took it. There was no reason to throw him out of court.
No, but I don't think that there was particularly a reason to throw him out of court. Like, he was evil, but he wasn't insane.
And then he took his standby counsel for the purposes of sentencing,
which was a smart decision.
Which was a smart, rational decision. So he sat there, took it quietly, then made a smart decision afterwards.
But I think that's the difference between him and Brooks is at least Summers wasn't a lunatic. I mean, he was, but you know what I mean? Like, it's a different type of crazy.
It really is. Although I think I like what happened today too, when he comes out and he tries to make a fuss out of the Reddit thing. I get it. But his opening statement was, I don't think the prosecution was involved. I'm not involved, and I don't think the judge was involved. Well, nobody else thinks that either. But it was an odd thing to put on the record from him.
He was strangely respectful this morning, actually. That's a good point. I think that he might have, who knows, you go through the stages of grief, maybe he finally got to some sense of acceptance.
I think it's too late for another box fort, but you never know. You never know. Maybe he'll be behind the boxes because he doesn't want people to see his reaction. I wouldn't put it past him. We shall see.
Guys, we get it. The verdict's been reached. 35 minutes. We'll cover it.
And I'll go over a couple minutes before to make sure we don't miss it too. But
yeah. Like I said, I still have Law and Crime on my phone, so I'm keeping an eye on whenever they move the camera.
Yeah, that's true. They could gag him, although the reading of the verdict just doesn't take long enough to bother with gagging him.
No.
If you needed to, it would be mid-reading.
I mean, at this stage of the game, once you have everything basically decided, if they have to, they could just put him back in the cell in the courtroom. I mean, who cares?
The bailiffs could just grab
there's no further prejudice. Sorry,
right.
I kept talking over you.
They would. I'm guessing they put him in the courtroom next door, just out of convenience. But yes, they certainly wouldn't have any problem doing any of it at this point.
No, I mean at this point, there's no prejudice. They've already come to a decision.
So you do here at Law Talk with Mike. You get bonus coverage. You get fezzes. You get the wizard attorney.
There you go.
And we also had a little stop in with Judge Manning. Judge Manning was boring this morning. It's not her fault. She's got a murder trial going on and she's calibrated appropriately.
Yeah, no, it was appropriate to Corman. I have to say,
Okay,
actually,
let's see how
I thought
this
that
is gonna work.
witness was doing pretty darn well, but it's just not super interesting. I mean, it's interesting, but it's not
Okay,
snappy.
we might in court sooner.
Will Brooks be in jail clothes or not? If I were
Can
him,
you all hear me?
one last time.
Yes, Your Honor.
Yes, Your Honor.
I'm gonna kind of join back in on my computer, but right now I am on my telephone.
Come on, let's get some vintage Lanice Bryant here, like this.
Oh, sweet Jesus! What? And it is not connecting. All right. Did you all hear me call the case, or did I get disconnected while I was calling the case?
I didn't hear the case being called, Judge.
Okay, so this is case number 22.
Mike's not encouraging them.
4539001, the people of the state of Michigan versus
That'll
Crystal
be interesting.
Mary.
He might have an outburst.
Charged with one count of assault or assault battery, one count of trespass. Today is the date set for a pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people. I also have the complainant witness, Mr. Gaston, on Zoom this morning. Mr. Gaston, unmute yourself and state your name for the court.
Eric Gaston.
And then which one you now?
I'm sorry, Judge. Your connection is a little unstable, so I didn't hear you.
Enjoy one.
I said, am I the host of the meeting now?
Yes, I did make you host, Judge.
Disrupting the youth here.
Okay, that means you're no longer co-host?
John.
It looks like I am co-host now.
Okay, so I'm not really
You're not the
able
influence
to
you want for 1L.
do much of anything.
I actually like. I'm a weirdo.
My phone. I don't know how that's going to work, but so make Miss oh, you can't now because I'm the host. Okay, I'll figure it out in a minute. All right, Miss Stevenson, your appearance, please.
Janice Stevenson on behalf of Crystal Nieves. Ms. Nieves, ma'am, please unmute and tell the judge your full name.
I'll put it this way: 1L was more fun than actually.
Hello, my name is Crystal Nieves.
All right, today is the date set for a pretrial conference. The complaining witness is present. How are we proceeding?
Your Honor, Ms. Nieves will continue her plea of not guilty. We'd ask that the matter be set for final pretrial conference. We would request discovery, and we would like to address bond.
Court is going to continue a not guilty plea on behalf of Ms. Nieves and set the matter for final. The wheels of justice are going to roll you right into the Wayne County Jail. Conference for January 25th.
Well, that's a great comparison between the
At
quality.
9 o'clock a.m. Discovery should be submitted to defense by January the 3rd.
Thank you.
As to bond.
Thank you very much, Your Honor. We have no objection to the no contact condition continuing. Ms. Nieves, however, Your Honor, lost her housing in Michigan, Your Honor, and has returned to the state of Massachusetts. And we're asking for permission for her to remain in Massachusetts, Your Honor.
As long as it does not interfere with any in-person court hearing that I schedule, she can remain in Massachusetts.
Thank you, Your Honor. With that, we would have nothing further.
Oh, law and crime. How do you get away with having a static image?
All right. Then we're all set. Everyone have a great day and stay safe.
Excuse me, Your Honor.
Oh, I'm sorry.
Good morning.
Sir.
Good morning.
I'm sorry. I'm sorry, Mr. Gaston. If you have any questions, I'll reach out to you after I'm done with court, okay?
Thank you.
Thank you.
Oh, he shut up. Oh my God.
All right.
That's awesome.
Okay, then we're all set. Ms. Muldrow, you're a co-host, correct? Ms. Muldrow?
I am not, Judge.
Why is Ms. Muldrow not a co-host?
Thank
You
you.
have been a co-host all day?
I have not.
You ain't even say nothing because you didn't want Ms. Stevenson bothering you. All right, so I'm gonna make Ms. Muldrow, actually, Ms. Muldrow, I'm gonna make you, I'm gonna make you a co-host.
Yes.
And then can you take over the controls
Yeah,
for me
I will.
and remove the individuals? They are all set. So Mr. Gaston, if you have any questions, you can call the prosecutor. And you all are free to log off, or Ms. Muldrow, you can remove them from the meeting. Ms. Nieves and Mr. Gaston.
Thank you.
All right, you're welcome. I'm ready on Maya. Ms. Muldrow must don't know how to remove them. They still on my screen. Can you remove them from? Here we go.
Come on.
I'm
Zoom
ready
works
on
for
Miles.
like 2 years.
This is.
No.
Is the witness on screen? Can he come on screen, please?
The witness left, Judge. I don't know. She just left. She was just on screen. She just left.
Ms. Muldrow might have removed the wrong person. Who is? Oh, okay. Well, maybe she misunderstood. I don't know. This is case number 224539201, the people of the state of Michigan versus Madeline Renee Miles. And please know that I cannot see the waiting room. I'm on my phone. I cannot see the waiting room. So if you all see the waiting room, then you have to kind of bring my attention to something. All right, the defendant is charged with 1 count of assault or assault and battery. And today is the date set for a pretrial conference appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people. Judge, the complaining witness has returned and I let her in the main session. Ms. Snipes, let me just double state your name for the court.
Yes, my name is Angelica Christine Snipes.
And for the record, Your Honor, Janice Stevenson appearing on behalf of Ms. Madeline Miles. Ms. Miles, ma'am, please tell the judge your full name.
Ooh.
Get better, buddy.
We can't hear in the courtroom.
Thank you.
Madeline Renee Miles.
For the record, we agree. It is kind of a loopy system.
Today is the day set for pretrial conference. How are we proceeding?
Thank you, Your Honor.
Everyone
Ms.
was ready.
Miles will continue her plea of not guilty. We would ask that this matter be set for final pretrial conference, and we would request discovery.
Court is going to continue and not guilty plea on behalf of Ms. Miles, and I will set the matter for a final pretrial conference, January the
Didn't mean both.
25th at 9:00 a.m. Discovery should be submitted to the defense by January 3rd.
Yeah, the Sarah Boone case is in
Bond will
Florida.
continue with no contact with the
I
complaining
don't
witness.
know. It's a
With
sad
respect to the
situation. I don't know
January
if-
the 25th court date, the complaining witness has appeared today,
I don't know
and
if that's
therefore, ma'am, you do not have to appear on January the 25th. However, you may appear should you choose to. As the complaining witness, you may appear at all scheduled court appearances. With respect to that court date as well, I see that Ms. Miles, you have appeared in person and you have a right to do so should you choose to. However, unless there's testimony being taken or the court directs otherwise, the cases are held on Zoom.
Yeah, she's
And
cool.
so you are free to log in on
Talk to her.
Zoom instead of appearing on
But she can't come on here.
January 25th.
Practicing in
Is
Judge
there
Brandon's
anything
room all
further
day,
for the
trust me.
court?
Ms. Snipes has her hand up, Judge. I know we got a heavy docket. I'm gonna ask the court if there's something she has to say regarding the dates. Is there something you have to say regarding the dates, Ms. Snipes? Just yes or no? Okay, well, any other questions, Ms. Snipes? I'll call you after court, okay? Okay, nothing further for the record, Judge. Thank you.
Nothing on behalf of Ms. Miles. Thank you, Your Honor.
All right, then we're all set. Ladies, have a great day and stay All right, I'm ready on. Who else is present who else is present? Is Alan Armstrong or Dixon?
They're
I'm
all,
going-
everybody except Armstrong. So you have Allen in your waiting room, you have Dixon in your waiting room, Your Honor.
That was fun.
Are they ready?
Ready, Your Honor.
All right, bring in Alan.
Thank you. You know, it might be time.
Can Mr. Allen please turn on your camera? All right, this is case number 224539901, the people of the state of Michigan versus Terrence Joseph Allen. The defendant is charged with 1 count of license plate illegal use. Today is the date set for pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
And yes, Your Honor, Brandon Bird on behalf of Terrence Allen. Mr. Allen, please unmute and state your name for the record.
Well, I see what the problem is on my end. Apparently, there's an outage. Okay, they just sent. All right, go ahead and state your name, sir.
Terrence Joseph Allen Jr.
Thank you. Today is a day set for a pretrial conference. Mr. Bird, how are we proceeding?
We're asking for discovery in this matter and to set this matter for final pretrial, Your Honor.
Court is going to continue a not guilty plea on behalf of Mr. Allen. I will set the matter final pretrial conference, January 25th, 2022, 2023 at 9:00 a.m.
Oh, this trial.
Discovery should be submitted to the defense by January what date was I
Give
given?
you the
Third, Your Honor.
By January 3rd.
Your world confuses and frightens me.
Bond will continue. Anything further with respect to Mr. Allen?
Not from the people, Judge. Thank you.
Nothing further, Your Honor. Thank you.
Basically, this is Orange
All
County,
right, then,
Florida.
Mr. Allen,
She
we're
zipped
all
her
set.
boyfriend into a
Have a
suitcase
great day and stay safe, and I'll see
basically
you
had her
January
exposure. She was
25th
left in the crowd.
at 9:00 on Zoom,
But
sir.
it's not a fun case.
Okay, you
I'm
have a
ready
good
on
day.
Dixon. Thank you.
Ready on Dixon, Your Honor.
And then are we ready on, I'm ready on Judkins. I have that highlighted. Are we ready on Judkins?
Ready on
I think
Judkins,
the
Your
trial
Honor.
might just be sad. But when we get closer.
All right, bring in Judkins and Dixon, please.
Well, this is we're having audio issues now.
All right, who was it? Okay, ready on that Judkins, it looks like, is on.
I don't think that iOS.
You have on a scarf
do
with
it
the
right
color
now.
of your hair.
Do-rag.
Take that off, please. All right, this is case number 4632501, the people of the state of Michigan versus Hassani James Judkins. The defendant is charged with 1 count of failing to stop at a collision accident and 1 count of driving while license suspended, revoked, or denied. Today is the date set for a pretrial conference. I don't see Dixon. Did you all bring in Dixon?
He's left the waiting room, Judge. I don't know where he is.
All right. As to Mr. Judkins, pretrial conference, how are we proceeding?
Yep.
Yes, Your Honor, we'd like to set this matter for a final pretrial and ask for discovery.
Did I ask for appearances already? Because I got thrown off by the fact that I didn't see Dixon. All right, appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
And yes, Your Honor, Brandon Bird on behalf of Hassani Judkins. Mr. Judkins, please state your name for the record.
Hassani Judkins.
All right, and today is the day set for pretrial conference. Mr. Bird, you indicated you would like to set the matter for final pretrial.
Yes, Your Honor, and request for discovery.
The
That's
court
a
will
good idea.
continue not guilty plea on behalf of Mr. Judkins, and I will set the matter for final pretrial conference, January the 25th at 9:00 a.m. Discovery should be submitted to the defense by January the 3rd. Bond will continue with no driving without a valid license. Anything further with respect to Mr. Judkins?
Not from the people, Judge. Thank you.
No, Your Honor, thank you.
All right, then, Mr. Judkins, we're all set until January the 25th, sir, at 9:00 on Zoom. You have a great day and stay safe.
Okay, thank you. You too.
All right, thank you. Okay, moving down the list. Do I have Mac, Parnell, or Adams?
No, Your Honor.
I think
We do have a few unidentifieds in your waiting room, however.
Okay, you could bring them in and send them to a breakout room. Do I have Sharps or Smith?
Oh,
I think we can squeeze in a quickie.
You have Sharp and you have
I'm going to use Ms. Fowler's word. She now is in a throuple. And not only does she choose to be in a throuple, and she's shacked up in the bed with the throuple. Now, if anybody thinks this is okay, I am in the wrong world.
Those individuals who have just been brought into the waiting room, into the courtroom, if you received a request to go to the breakout room, please go to that breakout room and remain there until someone comes in to speak with you.
I think they have to be recreated, Judge.
Oh, okay. I can't do it. You can't do it? Okay, hold on then.
I can do it, Judge.
Because you know how to do it, Ms. Ritter, and she just don't.
That must be true. I don't know how to do it from
Okay, Ritter, and recreate the breakout room.
Okay.
And then open, you have to recreate, and then make sure it says manual. Then manually, and then open.
Oh, Judge, co-host doesn't have that privilege because I can't do it as a co-host.
Is this
Hold
where
on.
I say told you?
Yeah, it is, but that would it is, but then that would be petty. That's all I'm saying. Miss Ritter, I'm gonna make you the host, and then you're gonna have to make me the co-host.
Okay.
Miss Stevenson, she was just used to those host privileges she gets when I'm not here.
Right, right. Drunk with power.
Yeah, I got an alert on my cell phone that I'm using for court now. Apparently there's an outage in my area. Isn't it good that I have data on my cell phone?
Yeah.
I guess. Oh, we might have to, no, actually almost kind of done, depends. How many people are in my waiting room still?
Now it looks empty.
So we might get finished. I might not have to adjourn those other two.
Judge, I
Okay,
have a plea on Smith, and I don't know if we can do that today. I'm ready, but I don't. And I did do
Okay.
her advice to rights form, so.
okay. The person on the Rebel, did you all send them a request to go to the breakout room?
Can do that now, Judge.
Okay. Because it's too many people and somebody's still in a vehicle. The person on the moto, he's still in a vehicle. There's a person on an iPad. He need to go to the breakout room. Mr. Jones needs to go to breakout. I'm sure stretching my eyes to see this stuff. All right. You said you have a plea on Smith?
Yes, Your Honor.
Ms. Muldrow, how many cases do I have tomorrow? A lot. How many cases do I have Friday?
So everyone knows this is what court is usually like, as opposed to the insanity we've been watching.
Tomorrow we have. I said skip tomorrow. I think I have yeah 35 tomorrow.
We have 35.
Thank you.
Yeah, I know. I said that. How many do we have?
My law school didn't rank, but I was pretty much middle of the pack. I was like a B+ student.
Miss Smith, I understand you're going to take a plea on your case. Are you able to come back Friday instead? Unmute yourself.
I have a doctor's appointment Friday morning.
What time?
I have to be there at between 7:30 and 12, more than likely.
That's a long time. So Friday, can you come?
Yeah, that's with travel time. That's with travel time.
Your doctor's appointment Friday, or let me see. Miss Muldrow, next Thursday at, I don't know what I wrote down. I wrote 16 plus, which doesn't help. How many do I have November the 3rd?
Judge, we have 12, 17, 19, 25.
Miss Smith, can you come back next Thursday, November the 3rd?
Yes, Your Honor.
All right, Miss Smith, because I'm operating at a deficit. My internet, apparently there's an outage in my area and I'm on my cell phone. I can barely see.
I was going to say, yes, it is a lawful law.
I understand it's
They even
going
gave me
in
a
and
piece
out.
of paper when I was done.
Yeah, so can you come back next Thursday?
At 9 o'clock, ma'am?
Yes, ma'am.
Okay, thank you so much. Have a great day.
As well, thank you. That's what I was gonna ask. So can you all even hear me clearly, or am I like going in and out?
It goes in and out, Judge.
All right, so let's see. What were we doing on who's on my school? Do y'all know that?
So you have David Sharp at 9 a.m. is gonna continue for trial.
David Sharp. All right, so that's case number 244955101. When you say continue for trial on Mr. Sharp, you mean for jury trial?
Yes, please, Your Honor.
All right.
Lawful law class was an elective.
Well, let's
that
do
you could
it.
take.
Appearances right quick.
Of the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson on behalf of David Sharp. Mr. Sharp, please unmute and just say your name.
David Sharp.
All right, so I'm going to give you another date, Mr. Sharp. I will continue your not guilty plea. I'll give you a court date for that January 25th. Let's put Mr. Sharp for final pretrial at 9/17, and then we'll give Mr. Sharp a jury trial date in January. I hope I'm being clear. So Mr. Sharp, you're January 5th, and then I'll give you your jury trial date at that time. So put them on the docket for 9/17. All right?
Thank you, Your Honor.
All right, you're welcome.
Admiralty
Mr.
law
Sharp, I'll
actually
see you
is a
January
serious
25th
field
on
of law,
Zoom.
and it's hugely specialized, but they have no idea what that
Didn't
actually
hear me.
means. The
Yeah.
stop says.
Okay, that's Lane
I have
and
a family friend who's does
Robin.
admiralty law.
Robin. So Lane, what is Lane's schedule?
Lane has a review and he was not on your adjournment list.
Okay, let's get back to the verdict so I don't screw this up.
Yep. Nothing yet
let me
on
see here.
one crime, but
Let me see here.
we'll get there.
We want to share that. No, we want to share this. All right. Well, here we are.
Seems like we're about 7 minutes away.
Seems like old times. So
I'm looking forward to this being over.
Yeah. Oh, wait. I should get rid of my what's this thing here? Let me get rid of this deal. Because we're back. We're back, baby. We're back and ready for a verdict.
Oh, I can't wait.
How's that? Well, I can't see it. Maybe I can see it here. The chat thinks there's an overwhelming possibility of a meltdown.
I think that is an extremely likely possibility.
According to my very scientific slapped together poll. That's what I think. It's pretty likely. The only thing that could save him is that it just doesn't take that long. But there's so many counts. If you're going through 70 counts or whatever, 67, 67. It doesn't really matter. But if you're going through that, that will take 10 minutes of reading. And if someone's just losing their freaking mind, yeah, you got to put them in the other room.
Yeah. And like we were saying before, there's no prejudice anymore. They've already made their decision. So they can do whatever they want with him. Oh Lord, I'm looking forward to this being done.
Well, thank you, John. Right. You hung with me through this. Everybody go over and subscribe to his channel, Jay Robine. He's in the description. He just started. He's killing it. He has a really good video on Illinois v. Allen and such.
Trial by combat, folks.
Trial by combat was excellent. Excellent.
That was a lot of fun.
Oh, 100%. 100%. After this thing's right, he's going to say, you guys never had jurisdiction. Of course he's going to say it.
He's going to hear guilty on the first count and lose his mind.
Of course I've got my fez. I've got my fez, for the sovereign citizen moments. I've got to be ready.
Kathy, I should do the onion brief. I know people have done it, but it would be fun. That would actually be a nice little palate cleanser after all of this.
That's what we're here for. The chat is never wrong. Taser cuffs, maybe that'd be good. That's what I'm pulling for. I don't think it'll happen, but I'd like to see I'd like to see him stand up and lunge and just have him hit the taser cuffs. Oh, that'd be spectacular.
Can you see him jumping over the table and trying to?
Yeah.
It's possible. Yeah, he's got nothing to lose anymore.
What's he gonna do? Get another life sentence? And I'm guessing they're well aware of it, and they'll have bailiffs stationed appropriately for such an out. I mean, anybody who's getting sentenced to life or death, you got to look at that as a possibility.
Why in some cases the jury determines sentencing and others it's just a judge that determines the sentence? They don't.
That's cats.
The jury doesn't decide the sentence. They just decide, for instance, if somebody's death eligible or not. The judge is always the one that pronounces the sentence.
Sometimes they impanel a separate jury on a death case just for the sole question of whether or not they get the death penalty.
Well, the issue is death eligibility. The judge can still disagree with the death penalty.
Almost 73,000. Come on, people, get me over 73. Get me over 73. Damn it. I say to the people who have already subscribed to me. I don't know what you're supposed to do. Have your dog subscribe. Oh, good Lord. Well, we'll still be doing stuff.
Yeah, we'll find things.
I might go sit in a sensory deprivation tank for a few days.
Yeah, that's not a terrible idea.
Look who's here.
Hello.
Miss Lily Bristow, how you doing?
Good, how are you?
Good. I know
Wayfair's
you're
Way
busy.
Day is here.
Oh,
Get
I'm
low
gonna get
prices
yelled
on
at now.
thousands
Here
of
it
items
comes.
for your home. Shop bedroom furniture from $79.
The stream just got 100% more palatable.
It
I
really
was trying to
did.
get caught up on all the closing arguments and everything. I was
State versus Brooks
trying to
appearances
watch
are
all
as they were
on,
before. I
people.
would make
Here we
just
go.
one note that Mr. Brooks is now present in a suit. And I will also advise that at 9:43 a.m. this morning, I was advised that the jury had reached verdicts in this matter.
That is
And
fast.
without anything further, I'll have the jury brought out.
Your Honor, I don't consent to being called that name and would like to address subject matter jurisdiction for the record.
You
as
were
yet to
stupid
be
last time.
Your
You
objections
need
are
to reserve
noted.
John for
We will
this
not be
verdict.
addressing subject matter jurisdiction. Please bring the jury out.
Would it be proven for the record, Your Honor?
Lily, we're gonna have
Just
to
a
get you
reminder to everyone
no.
that I do expect everyone in the courtroom to demonstrate appropriate decorum and courtesy as the verdicts are read and refrain from audible responses. Any disruptions may result in removal from the courtroom.
No.
Your Honor, is that a tacit agreement not to address subject matter jurisdiction for the record?
Jury's coming in. All rise, please.
I respectfully object to that ruling, Your Honor, and request the legal reconsideration of your ruling for the record.
Your requests
You
are
can
noted,
request
sir.
that all you
I'll
would
not be
like.
addressing that further.
For the record, may I respectfully reject that ruling and take exception to that ruling, Your Honor?
He seems defeated.
He knows what's happening.
Is that a tacit agreement and a judicial determination that you don't have to answer that question as a public servant, Your Honor?
I love that she's ignoring him.
For the record, may I request the legal or factual basis for your ruling, Your Honor?
It might have been a false alarm.
For the record, may I respectfully request a written judicial finding of fact and conclusion of law on this issue, Your Honor?
All your requests are noted for the record. They all are denied, sir. All rise. Jury's coming in.
For the record, may I respectfully move for an interlocutory declaratory appeal on this matter, Your Honor?
Wrong court, dummy.
For the record, may I move to stay these proceedings until this instant matter is adjudicated by a court of competent jurisdiction?
Denied.
Nope.
Based on what law or fact, Your Honor?
All of them. Every fact and every
Is
law.
that a tacit agreement that you don't have to answer that question? For the record, Your Honor, as a public servant? You don't have to address admiralty law or common law if this court is operating under admiralty law?
Oh,
Will not be addressing any of those issues.
I need a gavel for our next trial.
Thank you, everyone.
object,
Please
Your
be
Honor.
seated. Ladies and gentlemen of the jury, have you picked one among you to be the foreperson? All right, and I see it's your number 11. Have you reached verdicts on all 76 counts?
Yes.
All right, would you please hand all of the forms to the bailiff?
When a judge asks you and you're the defendant, has the jury reached verdicts on all 76 counts, you're not having a good day.
I think that's about right, Joe.
He looks terrified.
You're absolutely right. That is desperate fear in his eyes. Oh, look at that stack of papers.
Your Honor, seeing is that we've reached a verdict, is it necessary that I have these shock devices on my ankles?
Yes.
Yes.
Absolutely.
Three attorneys agree.
Even more so.
Next question.
Are you literally signaling that you're going to attack people? Maybe we should make sure that they work first. Oh, I know she can't wait to be done. The verdict forms are in. They can do whatever they want to them now. There's no prejudice.
Can you imagine the anxiety he must have in this moment, just sitting there watching her go through the papers?
Right. That is a look of genuine existential dread.
Mm-hmm.
That is somebody who just realized his life is over. And by the way, I think we were right. I think that literally was just how long it took them to all sign the papers. Stop feeding your trolls, Mike. I'm learning that. That's not a funny joke.
And I have confirmed that there are 76 signed verdicts and 76 unsigned verdicts. Which would be what I would expect. Right, I will read each one into the record. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 1 of the information, dated this 26th day of October 2022, signed by the foreperson, juror number 11. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 2 of the information. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer yes.
Bye, Brooks.
Hey, you are to be removed right now. You will not do that.
That was the gallery?
We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 3 of the information. And I should state as to count 2, it was signed and dated by the foreperson, same as to count 3. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 4 of the information. Dated this 26th day of October 2022, signed by the foreperson. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 5 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 6 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 7 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes.
That's all he had.
We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 8 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 9 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 10 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 11 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 12 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 13 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 14 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon?
I like that one.
Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 15 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 16 of the information.
I can't tell if he's boiling
signed by the
inside.
foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant guilty of first degree recklessly endangering safety as charged in count 17 of the information dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 18 of the information dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 19 of the information dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 20 of the information dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 21 of the information dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 22 of the information dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 23 of the information dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 24 of the information dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 25 of the information dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 26 of the information dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 27 of the information dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 28 of the information dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 29 of the information dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 30 of the information dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 31 of the information. Dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 32 of the information. Dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 33 of the information.
I would love to
Dated
write that
today's
opinion.
date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 34 of the information. Dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 35 of the information. Dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 36 of the information. Dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety
He's having an
while using a
existential
dangerous
crisis
weapon?
as we speak.
Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 37 of the information. Dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 38 of the information. Dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 39 of the information. Dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 40 of the information. Dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 41 of the information. Dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 42 of the information. Dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 43 of the information. Dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 44 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 45 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 46 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 47 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 48 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 49 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes.
I'm seeing a pattern
We,
here.
the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 50 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 51 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 52 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 53 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 54 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 55 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 56 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 57 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 58 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 59 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 60 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 61 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 62 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 63 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 64 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 65 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 66 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 67 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 68 of the information. Did the accident involve death to Virginia Sorensen? Answer, Yes. Dated today's date and signed by the foreperson. We, the jury, find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 69 of the information, dated today's date and signed by the foreperson. Did the accident involve death to Leanna Owen? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 70 of the information, dated today's date and signed by the foreperson. Did the accident involve death to Tamara Durand? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 71 of the information, dated today's date and signed by the foreperson. Did the accident involve death to Jane Kulik? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 72 of the information, dated today's date and signed by the foreperson. Did the accident involve death to Wilhelm Hospital? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 73 of the information, dated today's date and signed by the foreperson. Did the accident involve death to Jackson Sparks? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of bail jumping as charged in count 74 of the information, dated today's date and signed by the foreperson. We, the jury, find the defendant, Darrell E. Brooks, guilty of bail jumping as charged in count 75 of the information, dated today's date and signed by the foreperson. We, the jury, find the defendant, Darrell E. Brooks, guilty of battery as charged in count 76 of the information, dated today's date and signed by the foreperson. Mr. Brooks, would you like me to poll the jury?
Yes.
Members of the jury, I'm going to ask each one of you individually to stand up, identify your number for the record, and then state whether the verdicts read in open court are your true verdicts. I'll start with the foreperson. And I'll read your numbers first, so it's a little bit easier. So juror number 11. Were the verdicts read in open court, or are the verdicts, let me rephrase that. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 3. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 6. The verdicts read in open court, are those your true verdicts?
It is.
Thank you. Juror number 14. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 19. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 27. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 34. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 41. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 45. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 46. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 48. The verdicts read in open court, are those your true verdicts?
They are, Your Honor.
Thank you. Juror number 51. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. I should state for the record, I did have the alternates brought back in. Obviously, they did not deliberate, but it was important to have them because there are certain instructions I give at the end. All right, Mr. Brooks, are you satisfied with the polling of the jurors?
No.
I'm sorry?
No.
No.
The court is so satisfied with the polling of the jurors. The court now accepts the verdicts. Ladies and gentlemen, on behalf of myself, the citizens of Waukesha County, and both parties here, I want to thank you for the time and attention that you've spent on this case. Your service in this case is now concluded. There's no requirement that you maintain secrecy concerning what happened in the jury room, but you do not have to discuss the case with anyone or answer any questions about it. On behalf, again, of the court and all of the parties, we thank you for your service over the last 3.5 weeks. You are discharged and free to go. All rise for the jury, please.
Admirable service by the jury.
Well, hallelujah, the right thing happened. I'm keeping that there in case something else pops up, but I also giving you an opportunity. I asked Lily to come by. I said 5 minutes. I lied, and I don't want her to go full bridezilla on my channel.
Thank you. Be seated. Anything from the state at this time?
Your Honor, the state moves for judgment on the verdict as to each and every count.
Anything from you, Mr. Brooks?
What is judgment?
Given the verdicts from the jury here today, the court will enter judgments of conviction based upon the verdicts on all 76 counts. Court will also revoke bond. In this case, I plan on bringing the case in Monday, this coming Monday, the 31st at 1 p.m. to address further scheduling. What I would ask the parties to do between now and then is to determine how long you think each side will need to present their sentencing remarks, whether you anticipate anyone speaking on your behalf. If so, how many, how long, so that I can then look at my calendar and adjust and make sure that I have the appropriate amount of time to do that. I'm not going to sentencing on Monday. It is just for further scheduling at 1 p.m. before my afternoon case.
Judge, would you be willing to consider persons appearing by Zoom for sentencing?
Yes, I would not do anything different than what I've been doing since we started utilizing Zoom, and that is to make it available for both victims and family members of the defendant if they so choose to make statements over Zoom.
Okay, thank you. That helps us in our planning.
All right. All right, then. Thank you, everyone. We are adjourned for today. We'll see you all on Monday.
Well, at least he's nice enough to put his hands behind his back so they can put the cuffs on.
I honestly expected some sort of something from him.
Likewise.
Mike, you're muted.
Well, that's how we roll here.
Well,
I think what didn't happen happened. The worst YouTube mentor on the planet.
Oh Lord, that was I was genuinely surprised that he didn't have some sort of an outburst, but I think that he's still in shock.
And you pointed out too, like he had his hands behind his back. He object. Are you satisfied with the polling? No, I'm not satisfied that the jury unanimously confirmed that they convicted me on 76 counts.
Yeah,
but other than that, he rolled with it.
I mean, he had to know it was coming, though. I think that's why he was prolonging everything the way he was.
I don't know. John went all Eeyore yesterday because they wanted to look at some exhibits. He's like, oh no, we're gonna get a hung jury.
You know what? Look. In fairness, I always knew that this was probably going to be a clean sweep guilty verdict, but I just genuinely, it scares me when the jury asks questions. That always makes me think that there's something going on.
No, that's rational.
So, but they made the right call. I mean, first of all, great for huge respect. Hang on, I've got a plane flying by. Huge respect for Waukesha, because every single one of the witnesses, the public servants, everyone was so sharp, so on top of it. Great work by the judge dealing with this nonsense. It just makes your heart break that this happened to what seems like such a great community.
Yeah.
Yep.
Yeah, that was a wild one. Oh my God, we've done all this. And Lily, it's a good thing you weren't here. Actually, we were killing time because we knew we had to. So I tried to stop by and see Judge Manning for some levity. Okay. Oh no, she's got a murder one of a 17-year-old sitting. I'm like, come on, people. Can't we have some wacky TPO? You know that we can all.
Yeah.
No such luck today.
Well,
but we didn't have to vamp for too long.
No, I know you guys have been on this every single day, all day. So.
Well, we have. It was fun. I appreciate you coming by. I know you're busy as all get out.
Yeah, trying to get through it all, but
trying to get married. You gotta.
Got a few things coming up, so you know.
Yeah, you got bride stuff.
When I can. But thanks for having me. I was trying to like spark notes everything right before I got on. But it's just been so long that
nothing wrong.
I was trying to listen to the closings and all that stuff before I got on. I got like a little bit, but obviously not all of it. I mean, it was 2 hours of closing, so.
The only thing that happened recently, I mean, he drove into a parade and killed people. He was guilty. That one isn't hard to keep up with. The only interesting thing that happened the last day, well, it was all interesting, but the only thing that was new was there was some Reddit post, and the judge came in and said, "Oh, one of the jurors." The claim is that one of the jurors is on Reddit talking about the case.
Yeah.
And he tried to exploit that.
But I have to say, I think that the prosecution did a fantastic job this morning explaining that away in a way that's really clear, concise, and easy to understand.
When it first happened, we were all freaking out, but then literally within 30 seconds, I'm like, no, this is fake. I've heard enough.
Yeah. But you still have to, you don't have to prove it, but you almost have to. You know what I mean?
Yeah. Then he starts out this morning with it. I don't blame him. He doesn't have a defense. He's going down. If I was in his shoes, I'd say, "Oh yeah, this Reddit thing's very concerning," which he did. It was fun. It was comical.
Yeah.
Yeah, I showed my paralegal the video where he was like staring down the judge and acting all crazy, just to give her a little bit of a backstory. So that was interesting.
Well, we got to the right place. That is a beautiful.
Right. It took a while. But got there.
Yeah,
how long was that?
That's why I was smiling, because I like seeing justice be done, and we finally got there.
Yeah, she said it was 2.5 weeks, didn't she?
It was 2.5 weeks, and I skipped like the first part of the trial because the first part of the trial was literally the prosecution playing videotapes of him driving over people and killing them.
Or did she say 3.5?
I can't sit there for hours and watch that. It needs to be done. It's appropriate in court, but I'm not putting it on my channel.
Yeah. Well, I'm gonna get out of here. Gotta go finish up work. Do some billing.
Thanks for coming by. Nice to see you. Good luck with everything.
Yes.
When you get back, I will. You know what's gonna happen.
Yeah.
You're gonna have to start that channel, or you're gonna hear it from me.
I'm ready for it.
That's the way it is.
I'm
confident. I'm confident you'll get there.
End of
All right.
November.
Have fun. Good luck.
Thanks, guys.
And John. He's been with me through thick and thin, and there's been some thin. Oh, did John take some abuse? John, shut up. John's a ginger. John.
Yeah, well, you know what? That's okay.
Yeah, I'm with you. John's a pain in the ass, but who else is going to sit here with me freaking 12 hours a day? You got a limited pool.
Fair point.
John was the best available by a wide margin. I'm not going to lie.
Hey, you know what? In fairness, I'm okay taking the abuse because I also got a lot of love from your folks as well. So it's okay. And I was not going to make you do this alone.
You know who gets it worse than you?
You?
Kurt.
Yeah,
and
fair
me.
point. Kurt does
You
take
know who
a
doesn't
lot.
get any, and that I actually understand why, because he's cool as hell. But Ben, there's universal love for Ben.
I know. It's always interesting because Ben shows up and you see a million chats saying, "Oh, I'm so happy Ben's here." I don't get that.
Ben is universally loved. It was too bad. You know how he pops in and out. I think it's mostly like Wi-Fi issues or whatever. But he just popped out, and then we got the super chat from Kim Blandino.
Oh Lord.
And the thing is, I think it's probably a sock puppet, but I'm not sure Kim would do it. You know, I just don't think he can because he's in jail right now.
That might be a little challenging to get a smartphone in jail. I mean, it's doable, but I don't know if you'd want to use it for that.
That's what Kim would want it for.
Yeah, no, that's a fair point. That's exactly how.
I know what you're saying. Yes, most people wouldn't. I could see him enticing a guard into letting him have one, and here would be the exchange. I'll stop talking. I will stop talking if I have access to a cell for like an hour.
Yeah, I will.
And
I will
the guard's like, fine, I surrender. Sure.
And then I can go hop on Law Talk with Mike, and I'll go annoy them.
John, we love you. You do get a lot of love too. You do, in fairness.
I do.
In fairness, you get a lot of love. Oh, Lily gets nothing but love, of course.
That's true. Well, what I have not gotten in the last few days is a lot of sleep. So I might try and go crash for a little bit.
Go take yourself a nap and then make yourself a fresh video tonight.
Yeah, I have some ideas. People are still asking about the Onion Supreme Court brief. That might be a fun one to kind of take a little bit of the sting out of tonight. So we'll see. I'll keep people posted.
Yes, thank you, mods.
Yes.
It's funny because I don't I can't. I don't want to complain, but like there's more going on than it looks like. I'm not saying I'm good at it, but I'm like literally trying to do all these things behind the scenes to like keep it rolling. So no, like I can't monitor the chat, and then I find out people tell me stuff after.
Yeah.
Like I do not know if someone's getting out of control in chat. I can't read on that, especially, and I mean, it's a beautiful problem to have, but especially when it's been scrolling like it has.
No, I had some of your mods DM me last night that they had to toss a couple people because of stuff going on, and I appreciate that. That's awesome.
Yeah.
All right.
So
well, I'm gonna
thank you, everybody.
Hop off.
Thank you, John.
It's been a pleasure. I will see you all later.
All right. See ya. All right. And I just want to tell everybody thank you for coming by for the last week or so that we've been doing this. It's been a wild ride, but I've had a lot of fun with it. Hopefully I can get back to some fun, Cedric Simpson talking to Janelle stuff, because I really like that as well. All right. Thanks a lot, everybody. I will see you soon.